Okay, we're live. Okay, good morning. This is the New York City Board of Standards and Appeals review session for February 27, 2023. There is no public testimony during the review session. The first item up is a withdrawal 2020 91A 109 52 54th Avenue.
Okay, this is a motion to withdraw without prejudice.
So, Chair Shonda,
Aye.
Vice Chair Shabbat,
Aye.
Commissioner Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yu.
Is someone far away, Tony?
I'm sitting right here. I don't understand how that works.
There
All
may
right,
be
Commissioner
something
Yu.
with blocking your microphone or something.
There's nothing blocking my microphone. Good morning, Commissioner Yu.
Aye. You sound better now, Tony.
It said I turn my head this way, I guess, and then for the vote sheet, I guess. I don't know. All righty, postponement. Item number 25000BZ, 521, 541, 553, 563 LaGuardia Place, also known as Mercer Street, Manhattan. Decision items. Item number 3, 34660BZ, 211 Tapscott Street, Brooklyn.
Okay. So the applicant has provided revised plans with revised lighting plans, parking layout, signage analysis, and also 2 additional signs. One is that no parking on with regards to no parking on sidewalk and no idling of vehicles when parked. And the applicant has also revised the statement of facts accordingly. So I make, any questions or comments on the submission, commissioners? Everybody's okay with it. So I make a motion to approve with the following conditions. Regarding the soil cleanup per Atlantis, and this is per Atlantis Management's letter from 12/13/2022, which states that during construction, environmental consultant will be on site to screen excavated soils for petroleum impacted areas that may be encountered and will need to be removed. And if contamination is discovered, the applicant will work closely with New York State DEC and their waste management company to process, treat, and properly dispose of any impacted soils. So I want that letter and this be a part of the condition that it be done. Regarding lighting, all lighting sources that are located on the lot line adjacent to residential use shall be shielded from direct view and pointed down and away from residences to minimize any adverse effect on surrounding residences. And with regards to signage, all signage shall conform to C23 underlying zoning district, and no parking of vehicles on sidewalk shall be permitted. With that, motion to approve. Sorry.
Somebody said
Yes.
something?
Yeah. I'm sorry to interrupt.
Commissioner Shetta?
I would add to what you mentioned that the cleanup shall be performed according to or in compliance with the requirements of state and city and federal agencies that have jurisdiction over the site.
Okay.
So it's kind of an umbrella,
Okay.
including
Sure.
the consultant report. Yeah.
So let's cleanup shall be done in accordance with all the regulatory controls governing contaminated site cleanup.
Yep. Thank you.
Okay. Okay. All right. With that addition, motion to approve.
Chair Shonda?
Aye.
Vice Chair Shabetta?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Yoon?
Aye.
Application has been granted. Item number 4, 61557BZ, 154 Horace Harding Expressway, Queens.
Okay. The applicant has submitted revised plan, statement of fact, and a letter from the engineer from its engineer regarding the retaining walls, structural integrity. And according to the applicant's engineer, it states that the crack on the retaining wall requires a cosmetic fix and does not require a structural alteration. Commissioner Shetta, are you okay with the?
It's
You
their
have
call.
this
Yeah,
one.
if they inspected it and this is what they decided, it's their call.
Okay, all right, thank you. Revised plans also have been submitted, providing the square footage of the sales area. Commissioner Otley Brown, did you look at it? You're okay with it?
Yes, I am.
Okay, thank you. And additional landscaping that the board had asked the applicant to provide along a portion of Horace Harding Expressway and along the rear lot line. Those have been included in the plans. And a compliance chart also has been provided for 1954. Though I have to say, I think maybe I was not clear. I meant for all the years since 1954. I'm not going to hold up our decision because of this, but please, when we do ask for compliance chart applicants, we ask for compliance chart from the time BSA has had jurisdiction on this site and indicate all the various compliances. Many of them I know over times do get superseded. Indicate that, but indicate all the later ones, subsequent ones that have been put in place by former boards and how those have been addressed and to date. So this is the only time I'm going to make an exception of not differing because the compliance chart has not been provided, but any other case going forward, I will not. So I'm just kind of making that very clear for all the applicants.
Chair, we have our deputy counsel's hands up.
Hi.
Yes.
Hi, Chair. Would you like to condition this approval or the release of the resolution on receiving this compliance chart?
Yes, that can be done. Yes, absolutely. Yes. Let's, thank you.
I
That's,
asked for it, it didn't come, all right.
thank you. Thank you, Deputy Counsel. That's a good suggestion. So I'm then going to make a motion to approve with the condition first, as our Deputy General Counsel mentioned, that the applicant provide the compliance chart from the time DOB had taken jurisdiction of this site till present, showing where the prior conditions and where the compliance are still valid and if those are being met or not. And based on that, upon receiving that, the resolution will be sent out. And the other condition is all lighting sources that are located on the lot line adjacent to residential use shall be shielded from direct view and pointed away and down and away from residences to minimize any adverse effect on surrounding residences. Improvements to the landscaping shall be completed prior to obtaining a new CO. The current CO expires in June of 2023. So a new CO shall be obtained before October 2023, and the landscaping, we'll have enough of time between then to get all the landscaping in place prior to that. So with that, motion to approve.
And if you want to, Chair, I would add as well that the retaining wall be fixed per the engineer, the project engineer instructions. Whatever it was, like a structural alteration or it's just a cosmetic thing, just fix it, because the way it looks cracked is not satisfactory to whoever is gonna like be walking next to that wall.
Okay.
Thank you.
Thank you. All right. With that addition, motion to approve?
Chair Shanda,
Yes?
Vice Chair Shabeta,
Aye. Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 5, 61780 BZ, 77780 McDonald Avenue, Brooklyn.
Okay. The applicant has submitted a revised statement of fact, photos of improvements made to this, specifically to the area where the trash enclosure is kept, including removing the barbed wire and removing the graffiti. Also, the plan has been revised showing the out parcel where the refrigerated trash and trash is stored. So any questions or comments from the commissioners? Okay. I therefore make a motion to approve with conditions that the site and the area used for trash storage be kept free of graffiti and the fence along the trash storage area be maintained and be opaque. No barbed wires on the fence, and the gate to the trash enclosure shall be provided.
Okay, so the motion to approve?
Yeah, motion to approve. Yes, thank you.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 6, 2017 43 BZ, 140 Hendricks Avenue, Staten Island.
Okay, this was for an extension of time. The applicant has provided a letter seeking a 3-year extension of time to complete the construction and obtain a CO. Motion to approve.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 7, 2017 306 BZ, 1977 East 14th Street, Brooklyn.
Okay. Oh, wait a minute. Oh, all right. Well, can you read out the number? I think I have mine in a. This is 202050.
No, it's 2017 306 BZ.
Okay. All right. I think I. 2017 306.
1977 East 14th Street.
Yeah. I think I had the old format, so I hadn't changed the sequencing. Apologies. Yeah, no submission was required, so make a motion to approve with standard condition for enlargements that the removal of exterior walls and or joists in excess of those indicated on the BSA approved plan shall void the special permit. So with that, make a motion to approve.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 8, 2022-25A, 88, 63 75th Avenue, Queens. We must reopen first.
Yes, so motion to reopen.
Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Yoon.
Aye.
Okay.
Okay. So this is a GCL 35 application that was approved by the board on January 23rd, 2023. The applicant has requested a reopening of the application to correct the plan specifically with regards to the DEP condition regarding amended drainage plan. DEP had issued a letter of approval of no objection dated January 18, 2023. And in that letter, DEP did not have any objection to the project. And it also stated that regarding the drainage plan, that it may be feasible to amend it and can be done outside of the subject lot. Thus, the applicant is requesting to remove the requirement of amending the drainage plan as a condition, which was initially imposed on January 23rd approval. And applicant also did some minor changes that were made to the design, but these changes really do not vary or change the action that is before us, as long as these are all compliant pursuant to underlying zoning. So any questions or comments from the commissioners? Okay, everybody is okay with the application. So I guess the next step will be a motion to close and approve.
Motion to close. I don't know if we can close it. Well, we can close it. Do we want to vote this out, council?
It's up to the board.
Yeah, there is no submission that would be required, so it's just a revised, removing that condition. So I would like to make a motion to close.
Procedurally, fine, to do it that way.
Sorry, I did not hear you, Jan. Can
I just said procedurally, it's fine to close and vote.
Okay.
Vote to approve on the same day.
Okay, all right. Thank you. Thank you for the clarification.
Okay, so the motion to close first. Chair Shonda,
Aye.
Vice Chair Shabeta,
aye,
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Okay. Chair, a motion to approve.
I guess motion to approve.
Chair Shonda,
Aye.
Vice Chair Shabeta,
aye, aye,
you said aye? I'm sorry. Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Okay, application is ready. Okay, item number 9, 2020-50 BZ, 2328 Olean Street, Brooklyn.
Okay, the applicant has Vinroy, can you turn your speaker off?
Yeah, that's what I was trying to figure out what was going on there.
I think there are two Vinroy bells, so please turn both of them off. Thank you.
Yeah, turn your video off also. Okay,
Okay.
once again, 2050 BZ, 2328 Olean Street, Brooklyn.
Thank you. The applicant has revised the plan and the statement of fact and has also provided a floor area breakdown by zoning district. I have to say this was a complicated, even though it's a small site, but it's a complicated site given its unusual shape and the split zoning regulations. However, I have to say the plans were detailed and very clear, and the application was very clear in walking the board through the various regulations. So I want to give a shout out to the applicant team and the architect especially. So with that, I make a motion to approve with condition that the removal of exterior walls and or joists in excess of those indicated on the BSA approved plan shall void the special permit. Actually, I did, before I make that motion, do commissioners have any questions or comments? I'm sorry. Okay, everybody's
Okay.
shaking their head, saying no, they don't have. So that's the motion I have, is approved with the standard condition.
Okay, motion to approve. Commissioner
Aye.
Shonda, oh, Chair, sorry. Chair Shonda,
Aye.
Vice Chair Shabeta,
aye,
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application is granted. Item number 10, 2021-47 BZ, 2100 Hermione Avenue, the Bronx.
Okay. The applicant has provided a revised DOB objection sheet to include the side yard waiver, and the statement of fact also has been revised accordingly. Any questions or comments from the commissioners? Okay, thank you. So I make a motion to approve.
Chair Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
aye,
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Application has been granted. Item number 11, 2022-27BZ. This is 101 East 150th Street, the Bronx.
I think this is being deferred to March. It's being deferred to March 13th.
That is correct, Madam Chair.
All right.
Okay, appeals calendar, new cases. Item number 12, 2022-16A 664 Coney Island Avenue, Brooklyn.
Okay, just give me a second. Just scrolling. Okay, so this is an appeals case, an application to revoke a building permit, job number 321847695, issued by Department of Buildings on February 11th, 2022, relating to the issuance of building permit number 321847695-01-AL for the proposed additional oil change shop at an existing as of right automotive laundry facility, which is use group 16B, with 10 reservoir spaces at the subject site for not being compliant with zoning resolution section 32-25 based on the operation of the site. Specifically, zoning resolutions 32-25, which is for use group 16B, requires that automobile laundries to provide on the zoning lot minimum 10 reservoir space per washing lane. So this is a corner site, and back the automobile laundry use has been at this site since 1970. In 1922, the site obtained a DOB permit for the addition of a building for oil change shop and enlargement of the existing automobile laundry area with office, waiting area, and accessory use for Loop Center near the corner of Avenue C and Coney Island Avenue. The existing automobile laundry use contains one washing lane. Per DOB approved plan, there are 10 reservoir spaces, 2 rows of 4 and 1 row of 2 vehicles. It is accessed from a curb cut located on Avenue C and exits to Coney Island Avenue. We received response from DOB and also from the property owner of the subject site. So I will first go through what the appellant state, then what DOB and the owner, and then my conclusion of all the documents that's been provided. The appeal has been filed by the resident in the immediate neighborhood of the subject lot. Please note that the appellant had made an initial submission in 2021, BSA calendar 2021-13A, which the appellant requested to withdraw in March of 2022 for non-compliance with, and that 2021-13A was for non-compliance with reservoir space. Now, due to the non-compliance, the additional use, the applicant stated that due to the non-compliance, the additional use should not have been granted, and the non-compliance was due to illegal enlargement of the automobile laundry building that was constructed without a DOB permit. With the filing of the amended plan, 2021-13A application was withdrawn. The basis of the appeal is that the automobile laundry use does not comply with the required 10 reservoir spaces for the existing one-car wash lane. And that is, it is not compliant with zoning resolution section ZR 3245. Also, the site operationally does not comply with the approved plan due to physical limitations of the lot, and the placement of the oil change shop would further complicate the logistics and operation of the reservoir space. We also received a report from the appellant's engineer. It conducted a traffic and operational analysis of the existing automobile laundry use at the subject site. The report is dated June 27th, 2022. Also, site photos were provided. There was one set of photos that were provided from June of 2022, and we have the latest one from the appellant dated January 10th, 2023. Appellant's stated concerns are that the reservoir space must be separate from an area providing service, and in the case of a car wash, an area where preparatory work is being performed prior to vehicles entering the car wash machine. The appellant also states that the layout of the reservoir space is physically impractical to be utilized and does not provide the required 10 reservoir spaces based on the field observations, and that the intent of the reservoir space is to create a safe processing of vehicles and not create adverse effect on adjacent streets, traffic, and pedestrian. Appellant represents that the only way to achieve the legally required reservoir space is to have cars enter and line up from Coney Island in the area where the proposed oil change shop is proposed. We received a letter from DOB and documents from DOB and the documents includes the latest approved plan and the letter explaining providing a very detailed timeline of various permits and violations that were issued. DOB, as I say, based on DOB's letter, after issuing the permit to build the oil change shop and enlarge the automobile laundry use since February 2021, DOB has audited the job, issued several notice of intent to revoke approvals and permits, inspected the site to make the plans comply with zoning resolution section 32-25, and DOB also inspected DOB inspectors also inspected the site several times and issued ECB violations directing the permit holder to be compliant with the approved plans and zoning resolution. DOB states that the approved amended plans dated 11/1/2022 show 10 reservoir spaces in front of the automobile laundry, with the addition of oil change shop adjacent to the reservoir space and enlargement of the automotive laundry building, and an additional note stating that no washing or other preparatory activities permitted in the reservoir spaces. All of washing and preparatory activities must be done in an enclosed space per zoning resolution sections 32-41 and 32-412. We also received a report from the owner's engineers stating that, and photos and videos, and these photos and videos are from February 8, 2023. So that's the latest set of photos and that we have of the current operation or the latest operation on the subject site. Based on the photo, it shows that there are 10 vehicles queuing before the washing area. And the entrance is from Coney Island Avenue. The owner's traffic engineer also provided an assessment of the appellant's traffic report and conducted a field inspection in 2023, showing basically stating that the site is operating and is in compliance with a DOB approved plan. The operator's representative also provided, referred to a case law, Netchev v. Klein. So I'll get to all of this. What does all of this information for me in terms of my review of the documents is that that based on the most recent approved plans, the site complies with the zoning resolution section 32-25 by providing 10 reservoir spaces. In addition, the approved plan dated 11/1/2022 has a note, as I read out earlier, with regards to not allowing any preparatory activities in the reservoir space, and that it must be, any preparatory work has to be in an enclosed space per zoning resolution section 32-41 and 32-412. This further ensures that the 10 reservoir space would not be used for preparatory activity and only for holding the vehicles before it gets into the preparatory zone. These two elements respond to the two of the concerns that were raised by the appellant. This is further supported by the most recent photos and videos that we received dated February 2023. And in comparing these photos and videos of February 2023 to the latest one that was provided by the appellant, it does seem that that the site is operating differently from what the appellant had seen in even as late as January of 2023, and it is in keeping with the plan that was approved by DOB. So based on the engineer's report from the owner's rep, also there it seems there are attendants designated to directing the vehicles to the reservoir space. From Avenue C, there are attendants for directing the vehicles to the vacuuming area, and the attendants for prepping and entering the vehicles into the car wash area. So an operational change has also been taken place to make sure that the site is therefore in compliance with the approved plan. So I would say DOB's enforcement action has proven to be effective in bringing the site into compliance with regards to maintaining and operating 10 reservoir spaces and discontinuing the preparatory work within the reservoir space. Owner's representative also cited Nechev v. Klein case law with regards to the interpretation of car wash reservoir requirement, where the Court of Appeal upheld DOB's interpretation. DOB commissioners had interpreted zoning resolution to require, this is 32-25, to require the space on the subject lot for 10 cars in a line of traffic at the entrance to the car wash equipment or adjacent to the entrance in a manner which allowed those cars to maneuver and reach the entrance without leaving the lot, quote unquote. The representative further states that based on the interpretation of the reservoir requirement, the oil change shop, I quote, will not undermine the ability of the 10 cars in a line of traffic to maneuver and reach the entrance without leaving the lot. So zoning resolution requires 10 reservoir spaces for a 1-car lane. The text is clear that it does not specify placement or configuration requirement for the reservoir space. I'm assuming the interpretation stated in Nechev v. Klein is considered in reviewing and approving the site plans for new and existing automobile laundry use, and I would like DOB to confirm that at the public hearing. Based on the information provided, a review of case law and the zoning regulation, the site needs to be and is compliant with zoning resolution section 32-25 and also with regards to the preparation zoning resolution section 3241 and 32412. Also, the placement of the oil change shop should not, I believe, should not interfere with the maneuverability of vehicles getting into queue to get the car wash to get to the car wash area. Vehicles from oil change shop will have to be queued into the reservoir spaces as any other vehicles entering from Avenue C. I do not believe a revocation is warranted. It is not an issue of interpretation of the zoning resolution. It is a matter of operating and monitoring the site to conform with the approved plan and comply with the zoning regulations. DOB has the authority to issue summons and its and its execution of summons have been proven to be effective at the subject site. I do need a couple of clarification, and that is one is from the owner. The owner submitted an approved plan dated 10/14/2022. The DOB is referring to a later set of plans dated 11-1/2022, and it's the 11-1/2022 is the one that has the additional note with regards to preparatory area not being being within the enclosed area and not and no preparatory work will be happening in the reservoir. So I want the owner to confirm that 11-1/2022 is what the permit holder is confirming. And DOB needs to confirm that the permit issued on 11/18/2022, permit number 321847695-01-AL is based on the approved plan dated 11/1/2022. I have a additional question for Department of Buildings is that is there a mechanism like restrictive deck that is used by DOB that will legally bind the permit holder to the operation of the automobile laundry to further ensure compliance with the zoning resolution? It may be redundant, but it's just a question I have for my better understanding of the DOB enforcement process. Appellant in its submission also included the net check decline, but did not provide any narrative regarding it. So I'm not clear why that was included, but that's kind of long summary of the case. Vice Chair Shibata.
Thank you, Chair. The only thing I would like to add, I agree with everything you said. What I'd like to add is that upon an appeal, we're tasked with reading the zoning resolution. And in this case, the zoning resolution that applies here is not ambiguous. And so then we take this unambiguous language where we can't read anything into it because it speaks for itself. And we have to pair that against the determination of the, in this case, the Department of Buildings. I think that this is a reasonable interpretation. That's not necessarily the standard. The standard would be, did the DOB act in an arbitrary and capricious way in granting this permit? I don't believe that they did. I don't see, I agree with your position on this not being something that I would be interested in granting. I have nothing further to add.
Okay. Thank you. Commissioner Otley Brown.
I agree with both the chair and the vice chair on this issue. I feel that where the statute does speak to reservoir spaces, it is very clear that it just talks about dimensions and number of reservoir spaces and does not discuss whether or not they are positioned in one way or another. And I believe in the absence of any further direction, I would defer to DOB's judgment regarding reading the plans and making a determination whether or not the reservoir spaces that are actually proposed on the site actually comply with the zoning resolution in terms of the measurement and the use, which are the only things that are spoken of in the zoning resolution.
Okay. Thank you. Yes, thank you for bringing that up with regards to the dimension. DOB did refer to the dimensions as being another factor in determining the placement of the reservoir spaces, and those are driven from another section of the zoning resolution, which is the parking requirement in the Manhattan core. And as long as those dimensions can be fitted into the space, that is one of the another criteria. So thank you for clarifying that. Thank you. Commissioner Shetta.
Thank you, Chair. I don't want to be repetitive, but I do agree with all of you that the appeal before us is for me, it's impossible to think even of granting such an appeal. The reason why, because the 10 spaces that required for the reservoir are there per the statement of the applicant himself. So that the applicant in his paper, in his submission to us, all the time is talking about reservoir spaces, but the only reservations he took on that was actually that the reservoir spaces are being used for, let's say, vacuuming. And I do strongly believe that this is not an issue that trigger BSA action or requires an action from BSA to revoke the permit. Such deviation from the zoning resolution requirements, in my opinion, requires only an action from DOB, which I believe was taken previously, that DOB sent inspectors to the site, they issued summons, and the operator of such site should be playing with the rules. He should be complying with the zoning resolution requirements and with the note that his architect put on the approved site plan submitted and approved by the DOB. So I don't think this is a matter to be looked at as an appeal to BSA. I believe this is an enforcement issue that should be looked at by DOB. That being said, the only thing that caught my eye in the applicant submission is a statement that says that the 3 rows shown the 3 rows for the reservoir space. The third one of them is on the sidewalk. And I was actually digging the submission for a survey, and I found kind of like an old survey that's not that legit. And I did look at it, but when I looked at this survey and I tried to look at the site plan submitted by the appellant and the site plan that was approved by DOB, and I'm gonna let me just put something on my screen because I'm curious why this has happened. This is a submission from DOB, and if you look at the date, and I'm gonna zoom to the date right now. This is last updated January 22nd, 2000. And this is the note that no washing should be done within the 10 spaces, the reservoir space. And if you look here, this is clearly the adjacent building. I believe the property line is up to here. But if you look at the other site plan submitted by the applicant, I'm not sure, did the screen change or should I
The screen changed, yes.
Yeah, if you look at this plan, if you look at the date here, same exact date, 1/21 of 2020. But there is no there is no adjacent buildings. I'm not sure why is that.
Yeah, so
This is-
Commissioner Shetta, this is the board always, in the past, if you remember, we always used to ask the architect to update the drawings every time any change has been made. And I think this is again one of those situations where while the drawings were updated, but the updated drawing date was never reflected in that legend. So that's why I'm referring to the drawings. The previous drawing that you shared is the last set of drawings that DOB is referring to, and it has an approved seal with the date of 11/1/2022. So that is the latest set of plans, and that is the latest set of plans which DOB is referring to. However, the appellant is referring to a much older set of drawings, I think, and so is the owner. Owner is referring to a set of drawings that were approved on 10/14/2022. So we have 3 sets of drawings that have been submitted, and we all need to make sure that we are reviewing the latest set of approved plan, and the owner is fully aware that what is the latest set of approved plan that they have to meet by, and that the permit that has been issued has been based on that approved plan of 11/1/2022. And I don't know if the appellant is aware of the latest set plan, which is 11/1/2022. So that's That's the clarification I had. And so you and I are kind of saying that we're saying the same thing.
Thank you, Chief, for the clarification. And like I said, the only point I would be interested in looking into is how the third row of the reservoir spaces is on the sidewalk. If the applicant can clarify on this point or can prove it, I believe we could continue looking into that appeal. If this claim is not intact, I believe this case is over for me, at least. Thank you.
So when I'm looking at the DOB approved plan, dated 11/1/2022, I'm trying to understand your question of it being on the property line. The last row is on the property line. So I'm not quite clear. I understand the question.
Okay. I apologize if I'm not being clear.
Can't hear you, Commissioner.
You hear me now?
Yes.
Okay. There is a statement in the appeal statement of facts that says that the flow of the this one is on the sidewalk. If we're looking at if you look at that the site plan, my understanding is that property line is right here at the corner.
No, the property line is where if you see, if you zoom out, you'll see property line indicated. It's a dashed line. Yeah, it's not the fence. It's where it's
that one?
Inside the fence. Yes, that is the property line.
Even if it's that one, that plan approved by DOB clearly indicates that the third row is within the property. And this is my point. If the applicant can prove it to us, or at least to me, that this third row is outside, I am ready to continue looking into that. If this is not the case, I don't think there is a case there, and we should move forward on that. That's what I wanted to say.
Right, and I think this is all have to do with the operation of it and when the application by the appellant was filed and what the current status is.
I believe the only reason for that is the applicant wasn't aware about the latest approved city plans by DOB, maybe.
Yeah, okay, thank you. Commissioner Yoon?
Thank you. Excuse me. I agree that the 10 spaces have been provided according to the zoning resolution, but I have a question that I would like the DOB to clarify. In reading the Natchev case, it appears that the courts upheld the DOB commissioner's interpretation of the zoning resolution that the reservoir spaces should be arranged, quote, in a manner which allows those cars to maneuver and reach the entrance without leaving the lot, end quote. So that does seem a step beyond what the zoning resolution says. And the courts upheld that interpretation. And in this case, the 10 spots are shown in a way that one could believe that those cars can maneuver to reach an entrance without leaving the lot. But my question is in the oil change and the mandatory, as the owner states, the mandatory car wash after oil change and how that impacts the arrangement of the reservoir spaces. And if those spaces are to be accessed from the oil change facility without leaving the lot. And if DOB had considered that in its review of the plans. I see Vice Chair's hand is up.
Oh, sorry, Vice Chair Shibata.
I would wait till Commissioner Yoon's completed. I didn't mean to interrupt.
Oh, okay. Please continue, Commissioner Yoon.
I would like that clarification, and I think that those operations potentially will have an impact on how the reservoir spaces function. And so I'd like to understand if that's been reviewed at all by the DOB.
Okay. All right. Thank you. Any other question? Commissioner Shibata, Vice Chair Shibata, sorry.
Thank you, Commissioner. Thank you, Chair, and thank you, Commissioner Yoon. So my only concern with that is our review is and on an appeal is pretty limited to whether or not what is up on appeal, is it in conformance with the zoning resolution? And when there's an absence of text stating, if there was something in the zoning resolution that said, and we need to address activity on the lot that may be using that reservoir, that automobile laundry, that would be something that we could then act upon. But in the absence of anything and I know that I don't believe that's what you're asking, but I just want to state that to add to the zoning resolution at this stage, I think would be inappropriate, because it is something that goes against the owner's rights. And that's the very thing we're supposed to balance the property rights. And even when it is ambiguous, we are supposed to, in our balancing, when there is an ambiguity, and it could be more so for the owner, we're supposed to side on that side. So I just wanted to state something for the record.
Okay, but do we not then take into account case law that seems relevant? And these are honest questions. I'm not a lawyer.
Sure, no, absolutely. We certainly account the case law as that seems relevant. I suppose I read that case law. I've interpreted that in a different way than you did.
Okay, but even in the owner statement, they state, the Natchez v. Klein case, and they say not only will the oil change not impact or hinder, I forget the words that they use, the use of the reservoir spaces, it will actually enhance the operation. And I think those kinds of claims in relation to the case law are not clearly documented on the plan. So I'm just asking if that was discussed with the DOB and reviewed, given that it's a claim by the owner in reference to the case law.
So I think for that is definitely a way, a question the DOB can answer. But I think what DOB's responsibility is to make sure that the plan complies with the zoning regulation. And what the zoning regulation is requiring, that there be 10 reservoir spaces, and these 10 reservoir spaces be easily maneuverable. And that's one of the reasons why DOB was enforcing it, making sure all the various impediments and that were in the way that was affecting a smooth maneuvering of these 10 spaces be eliminated and removed so that it would not result in backup of vehicles and reduce the number of reservoir spaces. Now, with regards to the oil change, and this is I'm assuming, since this is a DOB commissioner's interpretation of it, the DOB carries that out in reviewing all cases, including existing ones where there could be an addition of a different use and making sure that they are. But in the case of Natchez, the main element is that what they're looking at is I just want to go back and read this so that I'm not misrepresenting, is that the 10 cars that are in line of traffic at the entrance to the car wash equipment or adjacent to the thing, or adjacent to the entrance, which it is in this case in front and adjacent, in a manner which allows those cars to maneuver and reach the entrance without leaving the lot. So in this case, that would work because there isn't any curb cut from this oil change onto Avenue C or onto Coney Island Avenue. And even the one that is existing in the Coney Island Avenue, the owner is saying that will not be used and has not been used and will be closed off. So the only curb cut that is on Avenue C is the curb cut that is aligned to the reservoir space. And so in reviewing this case, any vehicle that is going to come out of the oil change will have to wait within that area that is in front of the oil change building and the property line abutting along Avenue C before it can be queued in to those 10 reservoir spaces on a similar first come first basis that is happening for those vehicles that are entering from Avenue C. That's kind of how I looked at this site, and that's how, I'm assuming is what DOB is looking at it. And so the placement of the oil change building to me is irrelevant, and it really is not it's not the factor. It's really whether there are 10 reservoir spaces as the requirement is, and are these 10 reservoir spaces being used only for reservoir purposes and not for preparatory purposes. And that the site is, third part is that it is functioning that way, which DOB's enforcement has indicated that it can function once you remove all those impediments and barriers from the way. So that's kind of, when I looked at the NETCHEV, I looked at it from that angle, not in the way you're looking at it, but it is for DOB to respond to your question. And so I just wanted to be on record on that part.
I think,
Chair,
yeah,
I'm sorry.
Sorry,
I'm
sorry, go
sorry,
ahead.
Commissioner Yoon.
I don't know that I'm looking at it so differently. I'm just stating that they're saying that there will be cars not only coming from Avenue C, they will also be coming from the oil change. Was that discussed or reflected in any plan? But yes, there's other commissioners that want to speak. So I'll
Yeah,
start.
Okay,
so Commissioner Sheta first and Commissioner then Otley Brown.
Okay, sorry, Commissioner Sheta.
I can't hear you, Commissioner Sheta.
Yep, I was muting, sorry.
Okay.
Yeah, I just want to clarify why I said that I consider this as an operational issue, not a compliance with the zoning resolution issue. And hence, if it was a compliance issue, then that triggers the appeal to be like a matter to be before us. But the reason I consider this as an operational issue is that when you look at the site plan, when you look at the area for the reservoir spaces, the 10 spaces, there is nothing on that plan that was approved by DOB that indicate that there is something else to be done on this area other than being used as a reservoir space. It might be some cars coming from the oil change and going to that area. I don't care. It can be the car like coming to that area to wait and then go to the washing lane. The only issue that triggers us to look at this appeal and consider it, if it, let's say there is a note or there is kind of a text on that within that reservoir area that says this spot is going to be used for vacuuming, then that's a problem. Or if there is a maneuverability plan that says that a car that's coming out from the oil change and it's going out of the entire lot through that space, then this space is being utilized to discharge cars that being like subject to oil change out of the lot. But as far as this area, the 10 space area is being utilized to receive the cars that are going to washing, I don't think it matters where these cars are coming from, whether they are coming from the oil change facility or they are coming from the street, the Avenue C. It shouldn't matter for us. And that's why the only governing thing for us, for me at least, is when I look at this reservoir area, there is nothing that indicates that this area is going to be utilized for anything else other than being dedicated to accommodate the cars that are coming and waiting and then going to the washing lane. This is the bottom line for this case for me. Thank you.
Okay, thank you, Commissioner Sheta. Commissioner Otley Brown.
I just want to help to refocus the issue here. With appeals, we pay attention to the question that's being asked by the appellant and the final determination given by Department of Buildings in response to that. And we tailor our analysis to simply that question and that answer. And whether or not that question and that answer is appropriate. Is it backed up by legal theory? Is it backed up by the zoning resolution? Is it not an example of arbitrary and capriciousness by DOB? we don't then go on to consider other issues that may be ancillary to that issue. If we were to deny this appeal, and then at that point, the site puts into play the oil change operation, and there is an issue with that, then the appellant has to file a new appeal. But we aren't considering what the oil change operation is going to do in the future to the reservoir spaces, because that is not the question that's being asked here. And so I think going forward, when we have these appeals, we have to be very careful to tailor our analysis only to the question being asked and answered, and nothing else.
Thank you, Commissioner Otley Brown. Any questions or comments from the commissioners?
Does that mean that the DOB should not then respond to my question? I mean, I think that to me, it still seems related, but I hear what all the other commissioners are saying, and obviously there is institutional knowledge.
I don't have an issue with DOB answering the question, but they don't have to, because the focus has to be really tailored to the question. But I would say the appellant also had raised it, so it would be just best to put it to bed by having that responded by DOB.
Vice Chair's hand is up, Commissioner?
Yes.
No, I just wanted to, I was going to say something similar. It's a, you can ask the question. Obviously, that's something that is well within your right, and it's also important for the record. But is it what our review is? Is it what the zoning resolution intended our review to be based on when deciding, approving, or granting this variance, this appeal? That question wouldn't relate to the final determination.
Okay.
In my opinion.
Yep. Okay. Any other questions or comments? Okay. Should we move on to the next case?
Yes. Special order calendar. I'm sorry.
All right. Yeah. No. Let's go through the special order calendar.
Okay. Special order calendar, continued hearing items. Item number 13, 245 32BZ. 12305 101st Avenue, Queens.
Okay, just give me a second. I'm just going to pull out the. Okay. The application was last heard on January 9th. The primary comments were regarding the proposed parking layout, a clarification on the operational plan, revised signage analysis, and the notation for on-site lighting. The applicant has made a submission in response to these comments. With regards to the revised plan, the total number of parking spaces, it has been increased to 12 from 10, including a handicap space. The pedestrian accessible pathway has been revised. Trash container for 101 auto repair will be kept inside the building. The applicant in its letter stated it shows there'll be 3 different trash containers for 3 different operations, but I did not locate the other 2. I was only able to locate the one for 101 auto repair. My questions are, the applicant needs to stripe the remaining portion in front of parking space C12 for walkway, since the vehicles will be parked there and otherwise will be parked there, and therefore they need to stripe the portion of the frontage along also along 101 street, where it says no parking in the area. So the building is set back from the property line along a portion of 101 street, and while I don't think there's a no parking in the area sign has been posted. I did not see from the submitted photographs. So that area also should be striped to ensure that it would not be used for parking of any vehicles in addition to any signage that would be put up there. The applicant also submitted a revised operational plan. I'm satisfied with the clarification that has been provided. The plan is not clear, as I mentioned, regarding the trash enclosure. So those are my initial comments. Vice Chair Shibeta.
I agree with your comments, Chair. I have nothing further.
Okay. Excuse me. Commissioner Otley Brown.
I have no additional comment.
Okay. Commissioner Shetta.
Thank you, Chair. The only thing I have is they sent a letter to the neighbor regarding the noise and the other aspects. I'm not sure if they received any feedback from the neighbor. I haven't seen any feedback in the submission. If they did, I would like to get educated about the feedback. That's all.
Mhm.
Thank you.
Okay. All right. Thank you. Commissioner Yoon.
Thank you. I have no further comments.
Okay.
Do you need a minute, Chair?
Yeah, it's something just kind of, just give me like I'm just going to take a sip. Sorry. Okay. Next case, please.
Okay. Item number 14, 16755 BZ, 20-65 Clintonville Street, Queens.
Okay. The application was initially heard on September 12th. Board's comments were related to lighting, signage, landscaping, and overall site condition to comply with prior board grants. Now, the photos that were submitted, the latest photos that were submitted dated 2/23, do show improvements made to the site, specifically with regards to the removal of the banners, striping the parking area. But I think the drawing of the photos does show that more sprucing is needed. There is effort has been made to clean up the site, especially along the rear lot line, but more landscaping is needed. And also there are portions of the asphalt area that is broken. If you look at photo 8, the applicant is aware of that, and the owner/operator is proposing to improve this broken asphalt once the weather improves. And same thing with the landscaping. I would say the owner and operator shall improve the landscaping by providing more in-ground planting along the lot line, especially along the rear lot line. From the photos, it's pretty clear that the rear portion of the lot was recently cleared up. Thank you. But it's not it shall remain free and clear of debris or any parts of vehicles and other things that might be stored there. Regarding the revised plan, I noticed that there are 2 trash enclosures. There's a photo of the metal trash enclosure that is located on the eastern side of the building. It appears to be more like a storage container and not a trash enclosure. So I would like the applicant to clarify the use of the storage container, which is painted orange, brick orange color. The drawing should also show the 3 drains that are located on the site in the plan. So those are my initial comments. Vice Chair Shibeta.
Nothing further from me, Chair.
Okay. Commissioner Otley Brown.
Yes, hi. I looked at the photos that were given to us, and it appears like the landscaping has been cleaned. However, it still will need some refreshing in the spring because there are some areas that are bare, except for some shrub, like low grass. I looked at the new pictures to see if they still had merchandise for sale outdoors on the island. And I, because that was in the previous photos, And the new photos don't focus on the island area. So it's hard to tell whether or not they actually removed the merchandise from the island. So if they could just add one photo of the island area that shows that there's no merchandise for sale, I'd be fine.
Okay, thank you. Yes, I remember you had asked that question. Okay. Okay, thank you. Commissioner Shetta.
Thank you, Chair. I did ask him during the last hearing to submit pictures for the floor drains, indicating that they are clean, not clogged, operational. Because when I looked at the Google images, I wasn't able to see all of them. And they didn't actually submit the photos requested. In the latest submission made Friday, in one of the photos that's all the way at the corner, close to the air pump, there is one floor drain that is shown on that photo. However, the other two, they indicated that they have 3 floor drains. The other two, I couldn't locate any pictures for it. This is one thing. The other thing, if you look at the pictures submitted on that date, if you look at page 2 and page 5, page 2, I can make it easier and just share this. In that, you can see that there is a crack, diagonal crack, and what concerns me that if you look at the back of the wall, there is a fence, and apparently the grades on the adjacent lot is higher than the grades on the subject lot. Again, if I go to page 5. Give me 1 second. Page 5 actually can show page. This is page 8. Again, you can see the crack here, but if I go up, yeah, but I'm talking about the same crack, but it's a closer shot for the wall. I'm asking them to make sure that this wall is intact, especially if there is a great difference or differential between their lot. Yeah, this is the one. Sorry, page 10. Again, here you can see this diagonal crack clear here, and it's at this spot. It's going that way and that way. So they need to like have an engineer look at it, and if they decide that it is okay, it is up to them. That's all what I have for today. Thank you.
Okay.
Mr. Vinroy?
Yes, as it relates to the picture the pictures that would reflect the drain. The drain, there's the latest pictures that were sent on Friday the 24th. There are 3 small what you would call holes that reflect what the 3 drains would be. I don't know if everyone got a chance to see that.
Yeah.
We all see that, Commissioner Sheda? You saw the 3 drain holes with the cover over them? One is at right in front of the entrance door. That's the second one, but the first one is at the first picture with the drain is at right next to the sign where the air pump is. You could see the drain right there at the base on the ground. And then the second one would be where you're entering the facility, the main entrance to the facility. There's also another thing for the drains right there.
So Vinroy is referring to an email that he had sent to all the commissioners on Thursday, 2/23/2023 at 2:55 p.m., which includes the latest set of photos. So one of the photo Vinroy is referring to is photo number 4, which shows 2 of the drains, one in the parking striped parking area and one outside the striped parking area, right?
Yeah. And there's one as it relates to the entrance to the where you see a sign, a writing that says inspection. The background of it is red, and the inspection is in white.
Yeah.
At the base, you see a drain there. And then the other one is, as you go down to the next picture, where to the left, you see the green shrubs. There, it looks like there's some residue of maybe garbage or dirt. But if you look very closely in the parking spot, where the parking spot is the first parking spot, then there's a drainage hole there as well.
Yeah, I think it would be helpful if the applicant just walks us through these photos and indicate where the drainage, existing drainage holes are, and those should be indicated in the plans. Thank you, Vinroy.
Okay, all right.
Commissioner Shetta, continue.
Thank you, Chair. I'm done. I'm looking at the photos right now, and if they submitted the pictures requested, I'm fine with the case then. Thank you.
Okay, yeah, I think it would be helpful if they can walk us through those and indicate where they are. But nonetheless, it should be also included in the plans. Commissioner Yoon?
Thank you. I don't have any further comments.
Okay. Okay, next case, please.
Finroy, take your hand down. Thank you. New cases, sorry. Item number 15, 13546 BZ, 3802 Avenue U, Brooklyn.
All right, just give me a second. I'm going to pull out the plans. So we have received proof of service of initial filing and proof of hearing notice. Community board voted to approve with conditions. The conditions being speed bump to be placed on East 38th Street between Avenue U and Avenue V to slow down traffic, and an additional handicap parking space to be added to the plan. This is an application for an extension of term that expired in January of 2022, and an amendment to previously approved plan for an automotive station to expand the building to operate a gasoline service station with an accessory convenience store. Before I get into my comments, just with regards to the submission, there were two FEMA maps that were provided, and both don't show the same information. One shows that the site is in the AE flood zone, and the other one seems it is not. So I would like the applicant to clarify that. With regards to the compliance, while it's been provided, I think it may be moot in terms of a lot of the questions that are going to be raised. So most important part for me is the proof of continuous use. Based on Google Street View provided for proof of continuous use for years 2013, 2015, 2017, 2018, 2019, 2021, and 2022, it shows that there was an automotive repair use, but it does not show anything related to the gasoline service use. So my question is, when did the gasoline service operation cease to operate at this site? When I look through the zoning resolution, when I look through the previous board resolutions, as far as 2005 BSA resolution, the gasoline service station had not been in operation even then, and at least since 2003. So it has only been used, it seems, since 2003, based on what I can gather from the resolutions, only as an automotive repair shop, and not as a gasoline service station. So with that, I do not believe zoning resolution section 11-412 is applicable to be used since the use is no longer a pre-existing 1961 use. The gasoline service use had ceased to exist as of 2003, and now it's been 30 years that this gasoline service use has not been in operation at this site. So 11-412 will not apply, does not apply, since it's it's only applicable for pre-existing pre-1961 uses. So since the gasoline service has not been in operation 2003, and zoning resolution section 11-412 is not applicable, I also do not believe, therefore, the building can be enlarged. Furthermore, the proposed gasoline service station and an accessory convenience store will be operating 24/7 at this site. Though the applicant in its statement has not stated clearly the hours of operation of the automotive service repair, I doubt it is a 24/7 operation. It is more like your usual Monday to Friday till 6 p.m. and Saturday and Sunday maybe for a shorter duration. It is definitely not a 24/7 operation. So for the last 30 years, this site has not been operating as a 24/7 operation. It has been anything but that. So a 24/7 gasoline service with an accessory convenience store is a change in use that may affect the surrounding neighborhood. I would also like to know the status of the underground storage tank that was there with the prior gasoline service station, and the applicant needs to provide DEC spill reports. The board in its review, whether it's a special permit or variance, always considers neighborhood character and imposes conditions to safeguard the character of the surrounding context. In this case, visual and traffic, that would be a factor, noise, light, that would be a factor to consider. In 2005, the board had reinstated the gasoline service station. Now, to allow a gasoline service use with an accessory convenience store, the applicant will need to revise the application and file it under 11-413. However, since I mentioned earlier, it will not allow for an enlargement of a convenience store, allow for an enlargement of the building to allow for the proposed convenience store. If the applicant wants to enlarge the existing building, then the applicant may consider pursuing a variance application. So I don't want to go through most of my comments because I think that it may not be relevant since it's 11-412 is no longer applicable. However, I think there are certain things that in the drawing, should the applicant pursue this application, this site plan, the applicant needs to basically make sure that the statement of fact and the plans are consistent with regards to the total number of parking spaces that is being proposed. I think the plan shows 14, but the statement of fact refers to statement of fact refers to 14, whereas the plan shows 15 of those two are handicap parking spaces, which is what the community board had recommended. I also would want to see bollards placed along the concrete walkway to secure it from the parking area. The applicant is also, the revised plan is proposing to retain 3 of the existing curb cuts along Avenue U and widen 2 of the curb cuts to 30-foot width, and is also proposing just give me a second. Okay. The proposed 2 curb cuts that are the applicant is also proposing 2 additional curb cuts, 1 each, one along Ryder and along East 38th Street, each 30-foot wide. I'm not sure if a curb cut on East 38th Street is needed. It's a very quiet street. It's and it seems to, it would only serve the residences on that block and probably the block next to it. So at most, it's like an exit way from the residential homes on the block. So I'm not sure a curb cut on 38th Street is needed for this site, from this frontage. the as I had stated, I do not know what the current hours of operation of the automobile service is. The applicant should provide that. I don't have any issues with the proposed trash enclosure that is being proposed, which would be a masonry trash enclosure with steel gates. Landscaping, the site has really wonderful mature plants, and the applicant in its proposal is proposing to maintain those and add additional planting to provide further buffer. With regards to the lighting, I would want the applicant to add a note to the plan that all lighting sources that are located on the lot line adjacent to residential use shall be shielded from direct view and pointed down and away from residences to minimize an adverse effect on surrounding residents, and they should also provide a lumen study. With regards to the signage, the applicant is proposing to comply with the C1 regulations. So while whatever is there currently is any improvement to the site would be beneficial, but that's more of a later thing. The first thing is that the zoning resolution section under which this application has been filed is not applicable. The applicant needs to refile the case. All right, those are my questions. I do actually have one question, and that is with regards to the community board's condition. When community board proposed that condition of the speed bump, any location of the speed bump would require a DOB approval. Now, was the community board's concern with regards to the existing traffic flow or the future traffic flow that would be generated from the proposed operation? Those are my questions and comments. Vice Chair Shibata.
Thank you, Chair. I agree with you. The use existent in 1961 would be enlarged if they didn't change the use. So I agree with what you're saying. I don't know if they have grounds for a variance, but I believe that's the only way that they could get a enlargement. And I have nothing further to add.
Okay. So the application should be filed under 413, you're saying, right?
Agreed, yes.
Yeah. Okay, thank you. You're back, Commissioner Otley Brown. Yes.
Yes, I agree with the both of you that it wasn't entirely clear that they were entitled to the enlargement. And I have no other comments.
Okay, thank you. Commissioner Shetta?
Thank you, Chair. I'm willing to listen to the applicant feedback on the issue of the continuity. But for now, I do agree with what's being said or with this regard. The other point is the FEMA flood. There is difference between the two flood maps that were shown in regard that they are two different issue dates. One of them is December 1st, 2013, and the other one is February 1st to 2022. The things that caught my eyes is that the new one that was prepared after Sandy storm shows that the site is in zone X, while the older one shows that the site is in AE zone. I'm afraid that it was a mix-up, because my general understanding is that after Sandy, everything is getting more stringent. So if this site is an exception, I would like a confirmation from the applicant team with this regard, that the site was actually AE and now it is zone X. But of course, the difference between the two maps is clear. With respect to the lighting diagram, I have seen a lighting diagram in the plan set submitted. I believe that they're gonna need to resubmit if the design of the site plan changes. But there is.
Yes, you're right. You're right. Yeah. Yes,
there is a lighting plan on drawing Z-008.00.
Yes. Thank you for pointing that out. Thank you. Yes.
And that's all what I have for now. Thank you.
Okay. Thank you. Commissioner Yoon?
Thank you. The only comment I have I agree with what's been stated and just want to add, I believe the applicant also noted this in their statement of facts, but there's existing graffiti on a lot of the shipping containers on site, and that needs to also be dealt with in whether it's this application or a future application.
Sure. Thank you. Okay, thank you.
Next item, item number 16, 364-87BZ, 1719 Flatbush Avenue, Brooklyn.
All right. We have received proof of service of initial filing and proof of hearing notice. Community Board has approved this application. This is an application for an extension of term set to expire on March 23rd, 2023 for a continued operation of an automotive repair facility for 10 years at the subject site and waiver of rules for filing within 1 year or within 30 days after the expiration of the term. This is a corner triangular lot. Board has had oversight on the site since 1950. The last grant extension was granted in 2015, which would be expiring on March of 2023. The compliance chart only includes 2015 condition. It is incomplete. It needs to include all prior board conditions. And we need that. Without it, we will not vote on this application. Prior board granted 6 spaces that and as part of the prior, I'm sorry, I don't know why I'm having difficulty. It seems like a tongue twister. As part of the prior board grant, 6 spaces were required on the subject site. Now, the applicant has revised the parking layout based on the plan sheet A001. However, earlier site photos and based on Google aerials and street views of the parking, there is a lot of parking happening on the sidewalk on both street frontages. And so what I want to see to take place immediately is for the applicant to provide bollards, 5-foot permanent bollards, 5 foot apart for a length of 30 feet along both the frontages from the corner with chains. So this will further ensure that no vehicles are parked on the sidewalk or being moved into the into the property, into these parking spaces from the sidewalk. Also, it seems from the site photos, no parking on sidewalk sign that was required by previous board and has not been posted. It needs to be posted and photos need to be provided of that posted sign. As I stated, the compliance certificate and the chart with regards to the no parking on sidewalk is incorrect, and definitely based on the photos, it is not happening. The chart needs to be revised. For the board to grant any extension, the owner or the operator, whoever is responsible for maintaining the site, has to place these permanent bollards, as I mentioned, 5 foot apart with chain link fence from the corner, 30 foot into the lot on both street frontages, and has to place the no parking sign on sidewalk on the front on the frontage that I think is not Flatbush, East 34th Street. And I also want our compliance officer to monitor this site. With regards to the signage, it was non-compliant with prior grant conditions. Prior condition required compliance with C22 zoning, and the signage chart needs to be done for each of the frontage. I think that was not provided. Overall, the site condition, the curb cut along Flatbush Avenue is in poor condition and needs to be repaired. I did not see any photos of the existing clothing bin. I don't even know if there are small clothing bins containers that are available. I've only seen really giant ones, so I'm not sure how that can fit into this site, given that this site has very tight space for maneuverability and how it can be accommodated. So I would like the applicant to clarify that. Vice Chair Shibata.
Thank you, Chair. I agree with everything you said. I do just want to note, and it could just be my review, but the second statement of facts stated that signage was non-compliant, but what the signage calculations filed show compliance. So I just wanted a clarification on that.
Okay, so maybe that's where I'm picking up the non-compliant part of it. Yes, thank you. But I think they also provided the analysis for, they did not, the applicant did not break it up by 2 frontages. That still has to be provided, but that may be the confusion that is arising. Thank you.
Yeah, thank you.
Any other comments, Vice Chair?
No, none from me.
Okay, all right. All right, Commissioner Otley Brown.
I thoroughly agree with you, Chair, that this site is a very constrained site. Its shape is not conducive to having a large number of cars parked on site. And as a result of that, the cars are spilling out to the sidewalk. And we're not just talking a little bit. The operator of this site has just abandoned any idea of controlling the movement of vehicles or placement of vehicles on the site, and the vehicles are on the sidewalk, not even leaking out onto the sidewalk. They are lined up, because I did go visit the site. So they definitely should put the bollards and the chains in place. I fully agree with you. That would be an excellent solution to this problem. And I don't have any other comments.
Okay, thank you. All right, Commissioner Shetta.
Thank you, Chair. The only comment I have is regarding the lighting plan. And the reason I'm talking about this is I've seen before in one of the NOCs that were sent to applicants questioning values of luminous spread that are dropping from something to 0 just because there is a fence there. And actually, when the project manager did ask that applicant why it's dropping across the fence from, let's say, 1.5 to 0, the feedback was because there is a fence and the fence does not permit light to like go through, which is right. But in case of a light pool, we're not talking about just horizontal propagation of light. We're talking about vertical one and
Commissioner Shetta, unless I am wrong, I think this may be more with the next case, the question of the lighting that you're talking about. I think it may be more.
No, I'm not talking. I'm not talking about that as it exists in this case. But the reason I'm talking about this is if you look at the luminous spread in this case, you can see in 2 spots. One of them, it's dropping from about 1.5 to 0 because of just the fence. And in the other spot on the same lighting diagram, it's dropping from 1.7 to 1 across the fence.
I'm not seeing a luminous spread diagram. That's why I'm not sure we're reviewing the same case. That's why
Right. This case backs up against a wall.
Yeah, there is no fence. This is 364-87. This is a triangular site. There isn't, it has 2
Oh,
street
yeah,
frontage.
right. I'm sorry. My bad. I'm looking at the next case. Yes, you're right.
Okay,
Sorry.
okay,
My bad.
all right.
Thank you. I don't have any further comments. Thank you.
Okay, okay. All right, you have no comments on this one. Okay, thank you. Commissioner Yoon?
Thank you. I agree with everything you stated. Also with Commissioner Otley Brown, I also did visit the site and saw the same thing. So in total agreement, and I have no further comments.
Okay. I remember, I didn't go to the site this time around, but I do remember from 2015 or Was I on the board? I may have been just about on the board, having the same issue. Yeah, thank you. Thank you, Commissioner Yoon. Any other questions, comments, commissioners? Okay, let's go to the next case then.
Item number 17, 3109 BZ, 11704 Supton Boulevard, Queens.
All right. Now, in this case, though we have not received any proof of service of initial filing and or proof of hearing notice, we are hearing this case. And the reason is that this is a problem site. And I did not want lack of serving notice to be used against us deliberating on this. It's really a nuisance and an eyesore for the neighborhood, and we need to act on it very quickly. And that is why we decided not to postpone the hearing, but to hear it and raise all the questions and comments. And this could be partly because the applicant's representative is new to Board of Standards and Appeals and may not be fully well versed with the requirements of BSA. Our PM, our project manager, did reach out to the community board. We have not received a community board approval, partly because they did not receive anything. And the community board did inform our project manager that it had not
Excuse me,
received.
Madam Chair,
Yes.
Vinroy's hand is open. Did you want to say something, Vinroy, or you want to wait till the chair is finished?
Vinroy, what do you have anything to add?
Yes, Chair, the applicant emailed a copy of the certified mail that would have been indicating proof of initial filing. However, it did not have an accompanying letter. All we have is copies that we received from the applicant to indicate that the applicant had sent proof to the affected parties.
So we
so-
only have received the proof of initial filing, but not the proof of hearing notice either.
Well, the applicant has eventually sent both proof of initial filing and proof of hearing in the form of copies of postal mailings. However, there was not an accompanying letter to the parties. We just have receipts from the postage. Those came in 221 and 222nd.
Okay, I did not see it in the file, so that is why I'm raising the question. Okay, all right. But it seems the community board did not receive anything.
In the last
So-
communication with them, they didn't receive.
Yes,
Yeah.
so somewhere something has missed. So I would recommend that we send a dismissal warning to the owner due to the failure to serve notice and failure to prosecute the case, because the community board has not received anything. And the documentation is not very clear as to whether it was served properly or not. And I think before we send the dismissal notice, based on what Vinroy just stated, we should just follow up with the applicant whether it was done properly. If it was not done properly, then I would strongly suggest a dismissal warning letter be sent. I also want our compliance officer to monitor this site, and the applicant, I think this is an application for an extension of term for a continued operation of an automotive service station, use group 16, which expired back in January 25 of 2021. I believe the applicant would also be requiring a waiver of BSA rules and procedure under 107-3B2 for filing more than 1 year after the expiration of the term. As I mentioned, this board has had jurisdiction on the subject site since 1955. My general comments to the applicant is that since the council is new, to BSA and may not be fully familiar with the BSA submission requirements, I am going to ask our project manager to provide samples to the council of the operator, so that they know what needs to be submitted. Because all the comments that I'm raising, and I believe my fellow commissioners will be raising, are questions that were raised in the notice of comment, and had the applicant responded to those comments, maybe I wouldn't have been asking a lot of these questions, because the response that was provided to the notice of comments was woefully inadequate. And I would say the applicant needs to, it is not just providing a one sentence thing, it is going back and revising the documents that's been submitted and clarifying and providing additional information where required. As stated, the site is not in compliance with prior grant conditions and agreements the applicant stated during the prior hearings and were reflected on the approved plans. For example, the curb cut along Fogg Boulevard is still in use and has not been removed. Garbage containers have not been removed from the front of the building. Additional street trees along Fogg Boulevard have not been provided, or any request to Parks Department also that may have been made. Proof of that has not been provided. Sliding gates were not installed at the entrances and the exits, as it was required by the prior board. Must provide a compliance chart of all the prior BSA grant, and we can provide a sample of that so that the applicant knows how to provide that information. In addition to providing the documents in response to the comments raised by the project manager and the board, the applicant must bring the site into compliance. With regards to proof of continuous use, since the term expired in January of 2021, the applicant needs to provide proof of continuous use since 2021. Project manager, please provide a sample to the applicant. The easiest one is always the Google Street View, but I would still suggest, since the council representing the owner is new, please provide a sample. With regards to the proposed extension of the term, the applicant needs to respond to zoning resolution section 11-41. Documents provided are inadequate and do not clarify if the lot area of the zoning lot has remained unchanged since 1961. The applicant in its response letter states that vehicles are no longer sold on the site. So this is a note to our council that the resolution should reflect this change and the site will be used only for automotive servicing. And we should have a note in the plan that no sales of vehicles on the subject site. Per existing plan, there is no access to the site as at the rear from Fogg Boulevard. However, the photos and the Google Street Views show that the gate is fully operational and that needs to be closed. So need to provide photos of the interior lot line conditions. From the Google Street View and the photos provided, there are several trailer containers located within the site and auto parts outside the building. With regards to the hours of operation, there was a condition, and the condition was that it would operate from Mondays through Fridays from 8 a.m. to 6 p.m. and Saturdays 8 a.m. to 3 p.m. Per response letter, the existing hours of operation seems to be less. It's from 8 a.m. to 4 p.m. Mondays through Fridays and Saturdays 8 a.m. to 1 p.m. I would like the applicant to clarify, is the applicant proposing to modify the hours of operation to reflect the current hours? With regards to the trash enclosure, as I stated, it is not in compliance with the prior grant. Trash bins should be located either inside the building, and since the existing plan shows that it is going to be located outside the building, it should be then located in an enclosure. And I would again ask the project manager provide a sample of the kind of enclosure the board has been directing the applicants to provide for trash enclosure. With regards to landscaping, provide photos of existing landscaping and fencing along the lot lines and within the site. Based on the Google aerial, there seems to be no in-ground planting along the rear lot line as shown in the plan. With regards to lighting, the The condition was that the lighting be directed downwards and away from residents. Applicant needs to indicate on the plan the location of the existing and proposed exterior light sources, especially along the rear lot line. Applicant needs to provide photos. Prior grant condition that the lighting shall be directed downwards and away from adjacent residents. Now, if there are any light sources located along the rear lot line, the applicant needs to provide a lumen spread of the existing condition. With regards to the signage, there was a condition that the signage shall comply with zoning resolution section C22. The applicant has provided a signage analysis not broken up by street frontage. And based on the analysis, it seems a total of 128 square foot of signage is existing. All are non-illuminated. So applicant needs to break up the signage analysis per street frontage. And I'm not sure if the applicant analyzed the signage that is mounted on the fence along Sutphin Boulevard. So overall, the site condition based on Google Street View and the photographs provided, there is graffiti along the perimeter along Fogg Boulevard. There is a lot of garbage and debris collecting, and tire parts and automobile parts stored inside the site. And it is in very poor condition. The fence, at least from what little I could gather, seems to be in poor condition. It's not opaque. Some of the opaque elements have come undone. And there was a violation that was issued actually by DOB for not being in compliant with BSA conditions regarding street planting and landscaping. So all that we are saying is that this site needs to be brought into compliance in order for the board to consider an extension of term. Vice Chair Shibata. Vice Chair Shibata. Oh, I think Vice Chair Shibata's screen is frozen. Can anybody reach out to, let me just. Okay. Let's go to, while we wait for Vice Chair Shibata to refresh his screen, Commissioner Otley Brown.
I agree with you that the site is absolutely not in compliance. I mean, landscaping, structures on the site that shouldn't be there, fencing, in every way, basically. And so I think the direction to the applicant should be go back to the previously approved plans, because we spent a lot of time on this site trying to direct them to become in compliance the last time that this case came before us. So they should go back to those previously approved plans and put into place everything that we set for them, with probably with exception to the cars for sale, since they want to discontinue that. So in that case, these spaces that was striped cars for sale could be striped cars awaiting service. But other than that, they need to go back to that point. That should be their basis point, and then move forward.
Okay, thank you. Vice
I'm
Chair,
back.
your
Yeah.
screen frozen, so
Yeah, thank you.
Before you did.
So I had the fortune of still hearing the vast majority of everything that was said. This case is problematic because we both have a application that is under prosecuted and a site that is problematic and not in compliance. I don't know if it was stated, but a dismissal warning letter was sent, and that is how we ended up getting much of the submission that is still woefully inadequate. I really recommend a very tight leash here, because this site needs to be brought in compliance or no longer enjoy the variance that they were given. So I don't want to see long adjournments for this type of case. And I agree with your statements that this is a new representative to the board, but I think the case manager should provide them what samples, but being new does not relieve the client from their non-compliance.
Mhm.
And I have nothing further to add.
Thank you. Commissioner Shetta?
Thank you, Chair. I agree with my colleagues. I believe the site is in very bad condition when it comes to compliance. In addition to the fact that the applicant is new to submitting to the board, I totally understand that. I do believe that the statement of facts is very underwritten. It needs to be like inclusive, much more than what it is right now. Too many details need to be added. Violations need to be discussed, etc. So I would agree that a sample need to be sent to the applicant to look at it and probably use it as a guideline. In addition to that, I'm looking at the previously approved plans and looking at what is called, and this is the way that new plans are entitled or titled. They called existing plans. And the amazing thing is when you look at the westernmost part of the site on Park Boulevard, the previously approved plan
Commissioner
showed-
Shetta, Commissioner
Shetta,
Shetta, you're breaking up. Can you please come closer to the mic?
Sure. Is that better?
Okay, better. Yes, perfect.
Okay. When you look at the southern westernmost corner of the site in the previously approved plan, next to the existing parking spots, the 10 parking spots, you're gonna see that it doesn't indicate that there is a gate there. When you look at the street view on Google, you can clearly see that there is an entrance installed there to allow cars to get in and out of the site. When you look at what is called existing plans, which is recently prepared and actually signed and sealed by a professional engineer, it doesn't show that gate. So if I were that professional engineer, I would be like thinking like very carefully before I put my signature and my stamp on a drawing like this that does not represent the existing conditions. That's not good for a PE to submit something like that, or sign and seal and submit something like that. That the landscaping is not existing. The landscaping all the way to the residential property, it's non-existent. I did look at the aerials from Google and I did look at the website that we have subscription to, and I can't see any landscaping there. So I would urge the board to, instead of just this planting strip along the residential property line, I would make it like a planting bed with the width, minimum width, let's say of 4 feet. The area that's right behind the building is currently used for car storage, maybe for parking, illegal parking. And for me, it looks like it's a car junkyard next to a residential building. That's unacceptable. So that condition needs to be tackled immediately. We're about to get into March, the planting season, and I believe they need to change the conditions adjacent to that existing residential immediately. Thank you.
Thank you. Commissioner Yoon.
Thank you. I agree with everything that's been stated. I did go to the site earlier this month and noted all the non-compliances that have been addressed already. They are definitely using that westernmost curb cut on Falk. The gate is open. There's also a sign on the site that is not shown or represented in any of their submitted photos, but they have a banner up that says, "We buy cars and vans, junk or running." So the applicant needs to address the purchase and the advertisement that's located on Falk Boulevard. This is when I was there a few weeks ago. Also, the engineer had submitted a certificate of compliance noting that by March 1st of 2023, that curb cut on Falk Boulevard will be removed, and also that all trailers will be removed. We're getting pretty close to March 1st, 2023. I'd like the applicant to address these measures and also note that as has already been stated, the plans need to be, the site needs to be brought into compliance with the plans, and the plans should reflect the actual existing condition. There should be no reference to proposed additions if those are already existing. We need to look at a set of plans that shows the actual existing condition. It's the verbiage on the plan, aside from the fact that so much of it is not correct, still indicates a proposal for an expansion. That's all I have for this site. Thank you.
Okay. Interesting. Thank you. Yes. So I
Commissioner,
think,
okay. I'm
Go ahead.
sorry, Madam Chair. Commissioner Shedd has his hand up as well as Carlo Costanzo.
okay, Commissioner Sheta,
Stand before me.
who had, I cannot
Carlo.
see hands being raised. Who had
Carlo,
their-
Carlo.
Okay, sorry, Mr.
Yes,
Costanza.
Madam Chair. No, I just wanted to just address something that Commissioner Yoon raised, or I'm sorry, not to her, but I think it's important that that the applicant addressed today whether there's dead storage on this site, if they're buying like parts or junk cars, you know, that's something we need to know.
Yes, that would be completely contrary to the grant. That's a very high intensity use in a residential district,
That's all I had to say. Thank you.
right? Yeah, I mean, this is a residential zoning district with a C23 overlay. Yeah, thank you. Yes.
Commissioner Shedd.
Commissioner Sheta,
Yeah, thank you, Chair. I forgot to mention that if you look at the previously approved plans, they indicate that the fence is actually a chain link 10 feet tall fence. But if you look at the photos, the Google Maps, the street views, you're gonna see that there are like the lower portion of the fence is made of a mix of like a steel bars and corrugated metal. I'm not sure that I don't like the appearance, the way that the fence looks. I'm not sure if the board is okay with a fence like this, made of corrugated metal.
that's a good question you're raising, because when I was looking through the past resolution, especially the 2015 resolution, the earlier resolution, the board had directed the applicant to remove those corrugated metal fencing treatment and replace it with chain link fence. So it seems even that has not been responded to. And Commissioner Otley Brown, you were there, so you probably would remember it more. But that's what I seem to remember reading in the resolution. So everything that we are saying is that this site is in compliance on all aspects of everything, and we cannot move on this application to grant an extension of term until it is brought into compliance with the prior grant. And I definitely am not comfortable granting a 10-year if it needs to be in a much shorter leash than that, which is the fault and the price the operator or the owner pays for not abiding by the conditions of the board. And the owner's representative council needs to be fully aware of it. This is not a cut and paste of drawings that are to be submitted and for us to rubber stamp it. And this is again another one of the site I want our compliance officer to visit and monitor. All right.
Thank you, Chair.
Any other questions and comments? All right, let's move on to the next case. Actually, before I go on to the next case, does anybody want a 5-minute break?
No.
No? Okay.
Appeals calendar, continued hearing item 18/2022-2A, 728 Court Street, Brooklyn.
I think I'm going to, the only thing on this one we were waiting for is a fire department sign off. And I believe that is still being worked on. We just got word from Chief Daly that they're still working out the conditions with the applicant. So I think it would be best if we second call this tomorrow And hopefully by then, fire department would have signed off on it, and we can then take the next course of action. So I would suggest that we second call this at tomorrow's hearing. This will be the first item on the agenda.
Yes, ma'am.
Okay.
Okay, so are we done?
Yes, so we are done.
Oh, so
So
this
before we go to, sorry, go ahead.
I have to say, this concludes the public review session.
Okay, so before we go on to the review session and move on to the public hearing, let's take a 10-minute break quickly and regroup. So it is whoever has the best clock, minus 12:05.
12:05.
Okay, so 12:15. Okay, all right, let's come back at 12:15.
Okay.
Okay, we are all back? Do we have a quorum? Yes, we have a quorum. We have 1 more minute. Okay. All right, let's start. It's 12:15 based on my clock.
Exactly 12:15. Okay, Steve, you want to put up the screen? Thank you. The New York City Board of Standards and Appeals. This is the public hearing for February 27th, 2023. The first case up is Appeals Calendar, New Cases, item number 12, 2022, 16A, 664 Coney Island Avenue, Brooklyn.
I guess we will have DOB representative, appellant representative, and the owners also, right?
Oh, recording wasn't on before, so I have to re-announce this case, sorry.
Yeah, that's fine.
2022 16A, 664 Coney Island Avenue. This is the Board of Standards and Appeals public hearing for February 27, 2023. Thank you, sorry, yeah, I realized that after. Okay, so this is Fred Becker, Mikhail Schenker, and I think Shane Rosengold. Shane Rosengold for DOB.
Yeah,
Kevin, you're in this, Mr. Williams, you're involved in this case? Okay.
I think he's representing the appellant also.
Okay. All right, well, it might be Mr. Schenker. Let me see. Mikhail Schenkner. Could you join us, please? Join us, panelists, please. You are the owner's representative, I believe. And Shane Rosengold, please join us, please. Thank you. Thank you, Mr. Schenker. Ms. Gold? Please unmute. Thank you all. Okay, so this is 2022 16A 664 Coney Island Avenue, Brooklyn. And you can proceed. You can, Mr. Becker, this is your case. You can proceed. You don't have to be sworn in. This is an appeals case.
Thank you, Tony. Good morning, Madam Chair, Commissioners, Frederick A. Becker for the appellant here. I listened very carefully to everything that was said at the executive session. There are two issues that remain that were, one was particularly raised by Commissioner Shetta. Yes, and these will be discussed at length also by our traffic consultant, Kevin Williams of Equity Environmental. The issue, as stated, and it's stated in the zoning resolution, is that there is no preparatory work to be done within the reservoir area. Our ongoing observation, as recently as last week, and Mr. Williams took his car. I've been there personally many times. Mr. Williams took his car through the car wash itself, is that there is still and has always been and will continue to be preparatory work, as is customary with a car wash, in that first row, which contains 2 spaces. It is customary and usual that the person exits, cars are cleaned in some manner, vacuum, garbage removed, some preparatory work before a car goes into a car wash. And therefore, we would be, since this was raised by Commissioner Shetta, and we've raised it in papers numerous times, we are saying that those 2 spaces, while on paper look like areas where you could have a car in a reservoir space, it in fact is not reservoir space. And to kick this down the road, as DOB is suggesting that if there's a problem, they will enforce it. If in fact the the oil change shop goes up, it can never be corrected. Additionally, we submit, and Mr. Williams will discuss this at length, is that, and as the chair mentioned this as well, that there is an issue of maneuverability. In fact, the chair's
I'm sorry, I did not say there is an issue of maneuverability.
No,
I want to be very clear.
No, I apologize. You said you raised the maneuverability. You raised maneuverability, I should say, and that
Can before we go to the maneuverability, can I clarify on what I said? Because I believe my statement is being tweaked a little bit. There is a deviation from what I said and what's being said now. Should I clarify that?
Yeah, if you can, because I think that would help Mr. Becker to
Yes, thank you.
reframe
But what I said is if we have plans indicating that there is an activity other than the storage of the vehicles that was approved by the DOB, then I believe there is an issue here. But this is not the case. The plans clearly indicate that the area that's like being assigned for reservoir is just being assigned for reservoir. The plans do not indicate that there is any other activity, including vacuuming, whatever is allowed or permitted within this area. That being said, if this is the case, and there is actually, and I'm not saying there is, if there is actually an activity other than the storage is going on within the area that is assigned for storage on the plans, that's an issue of enforcement. It should be tackled by the DOB, and according to their statement, it's being done. If they already issued summons after a visit from one of the inspectors from DOB, because they noticed that it's being used for vacuuming, for example. So that's what I said. I didn't say that the plans indicate such.
Thank you for the clarification. I was attempting to pick up on what you said, Commissioner Shetta, in that the plans have a note, for what that is worth, that says nothing to occur. Yet there is nowhere indicated on the plans where this work, which is customary and usual with a car wash, in fact, does exist. So we don't see anywhere on the plans where vacuuming or any prep work or whatever needs to be done, as is usual with the car wash that all of us have been through on numerous occasions. So we submit that based on observation, based on common practice, based on experience, notwithstanding, based on photographs that we've presented, that notwithstanding the 1 day of photographs taken by, or the video presented by the property owner, there in fact is not just the storage of cars. And in fact, DOB issued a violation to that effect. And there's no indication that that has stopped, notwithstanding this one note on the plans. What I was referring to with regard to the statement the chair made, and I apologize if I misquoted, is you had mentioned that a reservoir space should be easily maneuverable, the car to go from point A to point B. And it is our submission that, as Mr. Williams will indicate, that to go from the far left or the far right is not easily maneuverable. In fact, cars are not Lego blocks, and there is a distinct question of whether, in fact, it is even physically possible to move cars from the outer lanes, left and right.
Councilor, do you believe that that's grounds for the reversal of a permit?
I believe that I believe that the Department of Buildings has acted arbitrarily and capriciously in saying, we understand there's an issue, there might be an issue, it's an issue of enforcement. If there's a violation, we won't issue a permanent C of O. But once the building is up, this issue can never be corrected, and therefore they are effectively kicking the can down the road, and I see that as a mistake.
Why do you believe it can never be corrected? Wouldn't they just revoke they could just revoke at that time, couldn't they?
They haven't revoked the C of O for the car wash or revoked the C of O for the auto oil change shop.
Either or, they could address it. It
Well,
wouldn't
they
be a
haven't-
problem. It wouldn't be a problem in perpetuity, as you're stating.
Well, they never addressed the illegal enlargement, which displaced the legal reservoir space that occurred back in 2004. And the likelihood of the revocation of a C of O for the car wash is remote, and I would submit it's similarly remote that they would revoke it for, they'd have to come to you to revoke it for the oil change shop as well. I'm trying to avoid an issue ahead of time as opposed to down the road.
I would though say, Council, that DOB has been issuing notice of intent to revoke permits. And it has brought the applicant from what we saw from the earlier submissions of photos that you have provided to the later ones, that things are being brought into compliance. I still do not see why we need to step in to revoke when DOB has the authority to revoke and can exercise it to bring the site brought into compliance.
I understand what you're saying, Madam Chair, and I think I'll push this over to Mr. Williams because I keep repeating myself, is that the site in the normal operation of a car wash, there can never be compliance if there is going to be preparatory work, as is customary and usual with a car wash. And therefore, once the car oil change shop goes up, it will be a condition that can never be corrected.
Okay. Before I get to Mr. Williams, sorry, Mr. Costanza, your hand is up. Do you want to add something before Mr. Williams stays?
Yes, thank you, Madam Chair. I just wanted to clarify something about revocation. That's not something that would occur by our own fruition here. A revocation application would have to be brought by the Department of Buildings under a separate application, not under this purview of this discussion. I just wanted to be clear for the record.
Yeah. Right. Yes. Should we go to Mr. Williams, Mr. Becker?
Yes, please, Madam Chair.
Okay.
Madam Chair and members of the board, Kevin Williams, Equity Environmental. May I share my screen?
Sure.
Okay, I'm going to touch, obviously there are dramatic changes made since we initiated our report and as of last week and early February. Excuse me if my voice is a little light, just please let me know if folks can hear. What I'd like to do is first of all discuss this notion that Mr. Becker was remarking about. So the 10-car queue also comes with this notion of maneuverability. And I would express that, I have not witnessed a queuing setup into a single line queue at any location with a drive-through of any type, whether it be a car wash or a fast food entity. And that's basically why we're here, because what you will see from the photos that Mr. Amjadi provided, as well as the calculations that I had provided prior to the site being modified, is that the queue is not workable and in operation is not workable as expressed. And what happens and why Mr. Becker is suggesting that we stop this before it's built is because one of the cures is to use a portion of the area that's been accorded to the oil and lube facility. And so rather than making both use is problematic, we're suggesting a physical cure. Now, to that point, what I'd like to note here is in this first image, this is an image provided in Mr. Amjadi's report. This shows, if you count them, 1, 2, 3, 4, 5, 6, 7, 8 cars. And then if we go to another shot, that actually also shows 8 here, 1, 2, 3, 4, 5, 6, 7, 8. At no time in the field area is there capacity for 10. And I would remark that this goes back to the maneuverability issue. You simply cannot maneuver these cars around either as a valet type of service as has currently been appointed, or in some other fashion without removing one of those spaces for new maneuverability. And that's clearly what's happened here, is they cannot get all the cars, 10 cars onto the site in the arrangement they've suggested, because you have to have maneuverability space to move those cars around. Now, the other interesting thing I would like to note is there's been quite a dramatic change if you compare this to the site plan and to the previous setup at the site. So if you look at this plan set, previously the site, and I'll enlarge this, had been arranged where you can see the construction fence emanating from the existing brick building located here. And you can see just from looking at this picture, it would be very difficult to put 4 rows of cars. Now they've removed a lot of this side stuff, but that's the operation that they've had for a long time. Now, when you look at this picture that was in Mr. Amjadi's report, something strange here has happened where they've moved the construction fence over. Now it shows on the plans that there's an area of 3 feet, but I would submit there's a whole car length outside of this building. Now, when you refer to the plans here, you can see this is the edge. This is that brick. This is the entry of the building right here. And you go through here and you pay back in this area of the site. And so it appears, and what I would ask is to make sure that there are actually 3 feet and they haven't moved back the construction fence artificially to comply at the moment that Mr. Amjadi was in the field doing his observations, stating that these things would fit perfectly. But if you note, in between these 2 pictures, basically 1, 2, 3 rows are able to fit before you hit the side wall. And even if you basically have to go over another 6 or 7 feet. So I'm not saying that these are merely images. And when I was out at the site, I had not taken that close a look at the pictures, but I do believe that we need to verify that this construction fence is not placed in the area of construction so as to allow more space for cars to alight in the queuing area. So regardless, we have a queue that operates with at most 8, perhaps 9 spaces at the very tightest, as shown by a full queue setup at the site. And so the last thing I would like to say is when I went out to the site on Friday and drove my car through the drive-through, and there were different statements made that it'd take 1.5 minutes for a person to get their car washed and get the interior cleaned. It took 9 minutes and 31 seconds. And I calculated, or I counted it on my iPhone from the time that a car enters the car wash to the time that it gets fully cleaned and toweled off at the area on Coney Island Avenue. And I would note this. So it's possible, and I think this goes to Commissioner Shetta's point, is that this is potentially curable. However, there was debris removal. There was staging. When I was out here, there's a table that sets here that you get your ticket and people take, loose debris and that sort of thing. Previously, there was full vacuuming and, interior washing and all of that stuff going on, simonizing and everything. And now they've moved some of those operations out here. But I would also submit that if you look at some of the aerial imagery of this post-staging area, that when you have car load going in, you have the detail going in here, you have all these cars that were previously staged at the forefront of the car laundry. Now that is all taking place here. So you're going to have this whole area, congested, and that is what it is. But I will note the note that's contained on the plans now that was not previously contained no washing or other prep activity permitted in the reservoir space. All washing and preparatory activity must be done in closed space. Well, so the question that I have about the interpretation of this note is whether you can do all of that exterior washing and preparatory activity outside of the building after it leaves the site, because all of that, or at least a portion of it, some of it's taking place here and a lot of it is taking place out in the parking lot.
Mr. Williams, are you saying there is washing going on outside, or is it just drying? Which one are you referring? Because most of the car washes that I have been to, and I'll tell you, I don't go very often. Not that I maintain dirty car, but I just don't take that responsibility in the household. It's that, the car goes through the tube, it gets washed, it gets kind of air dried, and then when you come out of it, it gets wiped. That's so I want to be very clear. When you're saying car wash, is the car wash operation happening? Like, like, are they literally washing the cars? I mean, is that
No. So what I'm suggesting
be very careful
is
in
that
choosing sentences, words.
the prep work. So all washing and prep work. So prep work is being done, what previously prep work was done before the car laundry that was done in the queuing area has now been moved to the outside area after the car wash. Now, so I'm saying interior vacuuming, window washing, the greasing of the wheels or whatever. So all that prep activity, is now, or the majority of it, other than like removing loose debris, is being done outside of the car laundry or the car wash. Now, like I said, I don't know if the intent of that note or is to mean that all activities associated with the cleaning of somebody's car, so prep and washing, have to be done in an enclosed space. So my interpretation in terms of both the ZRs that are referenced is all of that activity is to be done inside, so because they're vacuuming, which makes noise and that sort of thing outside there's no area in the laundry that's all wet area. So that's being done on the outside, either before or after the car wash. That is, I don't want to go into more substance, but other than to note, so here's another one of Mr. Amjadi's pictures. And here's the effect of having an unmaneuverable, underparked queuing area that has this 2 rows of 4 queuing system, is that cars do back up. And I would also note, Mr. Amjadi, I believe, went out on a Wednesday, 11 to 12. The peak hour time for this car wash, as noted by Google Analytics, is Friday and Saturday. It's about double the traffic as it is when Mr. Amjadi went out there. So the idea is, a queue setup, a 10-car reservoir, is specifically designed to respond to needs associated with land use. And the implication there is it should function in preventing cars as best as possible from overflowing onto the street. And here, what we've seen in the other past is an absolute mess of cars in the opposite lanes, traveling in the opposite lanes. There's a car parked right in front of the car wash. So cars queuing to get in have to use the through travel lane to park there. And so the idea is, if the arrangement of the reservoir is not fulfilling the intended purposes of the requirement under the zoning resolution, then I would say that those two things, maneuverability and the numerical number of spaces, are indeed inexorably linked. And you have to demonstrate that queue can function. And I submit, if DOB were to refer this out to DOT, I guarantee you they would have issues with this operation at this location and with the queue set up as it is currently maintained. I have no other, preliminary comments.
Okay. I think this is definitely a DOB question to continue to investigate the site, as DOB has continued to done so. And as it has been proven from DOB's inspections and investigations that it is bearing fruit when done, and it needs to be more frequent, I guess, and more regularly. to put the pressure on the owner, and the owner's representative is here to carry the message that everybody's eyes and ears are on this site. So if you really want your operator, permit holder to operate in a legal manner based on the permit, then they need to rectify all of these issues, and DOB will be constantly monitoring it, and which has been successful. But that's just my suggestion, and that's why I had some questions for DOB as to are there other mechanisms and tools DOB uses in further tying and binding the commitment of the permit holder with regards to the operation of the site. So whoever, any questions or comments from the commissioners for Mr. Becker and Mr. Williams before we go on to who should it be next? I think it should be DOB. Yes. Any questions or comments for Mr. Becker and Mr. Williams from the commissioners?
Yeah, Commissioner Brown hands is raised as well.
Oh, okay.
Yeah, I just Commissioner Brown, you want to go ahead? I can do it after you.
Sure. I just wanted to say that, you know, I do understand that there may be an issue with cars queuing on the street, but that ultimately is not the focus of the appeal. The focus of the appeal has to do with the reservoir spaces, whether or not there are 10 reservoir spaces. And if the plans show that there is space for 10 reservoir spaces, and the owner of the site or operator can show that the cars can use those 10 reservoir spaces and maneuver into the car washing lane, and that the explanation they give DOB accepts that, then we can't go on to speculate as to what a flourishing business is going to do to that street. Because the use of the site is as of right, I believe it's a C8 district. So it's a high intensity commercial use. And so if the business is flourishing and the 10 car reservoir spaces are being used properly, it is still possible, entirely possible, that cars will then back onto the street regardless. And so that can't really be a basis for arguing that a business should not be allowed to operate in this particular space.
May I respond to that briefly?
Okay, go ahead.
Commissioner Otley Brown, I do agree, but in part, if 10 spaces were provided as shown on the plan and utilized, that would be a point. But as I stated, there's also the component of maneuverability in terms of the queue, and the implication that comes from that is that the queue is not maneuverable as designed. You will get unnecessary overflow, and as shown in the pictures provided by the owner's traffic consultant, it clearly shows that the site is A, not able to accommodate 10 cars, and B, there are serious questions about whether or not, in my opinion, just looking at the photos, again, subject to a determination, I would suggest DOB, this is the first thing DOB do, is to go out and make sure that they have not artificially moved the construction fence to demonstrate compliance, because as the pictures that I have show, they have maneuvered the construction fence some 5 to 6 feet to the left in the image I demonstrated in order to get the 4-car wide queue in there. And I would also just say, from the spatial separation and the amount of space shown on the plans and as measured in the field, there's something odd going on here. So that would be the first area that I think DOB should go and check, is make sure that the construction fence has not been artificially altered in order to demonstrate compliance with the 10-car queue.
Commissioner Shetta, thank you.
Thank you, Chair. I just want to remind everybody that DOB did do a good job on this side when the conditions were different from what they are today. They sent an inspector to the site and they observed the conditions, and they realized that there are some obstructions, and that's why they sent a notice of intent to revoke. And based on that notice, the conditions on site have changed. And my understanding is that all the obstructions have been removed. And the site now is in a totally different condition. Regarding the maneuverability issue, let me go back to the preparation thing. I would be like reluctant to use the term preparation. I use car wash all the time. I do have cars and I wash them. And when I go to wash my car, sometimes you can do the vacuum before, sometimes you can do the vacuum after the washing. So you can go to the lane, wash your car, and then go dry, and then vacuum clean inside, or you can do the opposite. First vacuum clean inside, and then go to the washing lane. And according to what I'm listening to now, is that the operation at the subject site has been tweaked to make the vacuum happen after the wash, meaning that there is no such preparation or like vacuuming thing that's going to be going on within the storage, the reservoir space. That's one prong of the issue. The second thing is the maneuverability, and again we're coming back to an operational issue. It's not a non-compliance with the zoning. The zoning resolution, as I read it, it calls for 10 reservoir spaces, period. If the inspecting in the plan examiner believes that the provided spaces are not enough, or they cannot be utilized efficiently, or the maneuverability has an issue to happen properly, that's the DOB code. And this is not, I wouldn't look at like this as a reason to revoke a permit that I believe, based on the facts before us, that's being properly issued.
All right. I think we have kind of said what we have to. Let's move on to DOB. Rosengo.
Sorry. Good afternoon. I'm going to begin by reading a statement that I had prepared. It's a shorter, it's a bit of a summary from our submission. And then I will address some of the issues that have been raised. Okay. Good afternoon, Commissioners. Shane Rosengold on behalf of the Department of Buildings. This is an appeal of the department's issuance of a permit for the proposed addition of an oil change shop at an existing use group 16 automobile laundry, otherwise known as a car wash, at 664 Coney Island Avenue. Bless you. Where the appellant claims the car wash does not have the 10 reservoir spaces required by zoning resolution section 32-25. The appellant is an individual residing on the East 8th Street block north of Avenue C. The most recent certificate of occupancy for the premises, issued in December 1970, authorizes, among other uses, an automobile laundry with reservoir space for 10 cars. The 10-car requirement comes from section 32-25, which sets forth uses permitted as of right in use group 16. Subsection B describes permitted automotive service establishments and states in relevant part, quote, automobile laundries, provided that the zoning lot contains reservoir space for not less than 10 automobiles per washing lane, quote. Here, only 10 reservoir spaces are required since there is only one washing lane. The zoning resolution does not include requirements for the placement or configuration of the 10 reservoir spaces. The zoning resolution does not define the term reservoir space. Section 13-25, which is a subsection of 13-20, special rules for Manhattan core parking facilities, provides guidance regarding the required size of such spaces, stating, quote, in no event shall the dimensions of any reservoir space be less than 18 feet long and 8 feet 6 inches wide. While the special rules for the Manhattan core are not applicable here, the section does provide guidance on the size of reservoir spaces, which is satisfied at the premises for 10 cars. Appellant alleges that an enlargement in 2004 of the car wash building filed by Directive 14 decreased the available reservoir space. He further claims that the proposed additional oil change shop would continue the existing unlawful non-compliant condition created by that enlargement. And actually, I just want to add in something in response to what the appellant's attorney said earlier. He called it an illegal enlargement. DOB does not believe that the enlargement was unlawful. You can do an enlargement by way of Directive 14. So actually, DOB does not, DOB disputes the characterization of the enlargement. We do not think there is an issue with the fact that the enlargement was done by way of Directive 14. So I just want to address that. In response to appellant's initial appeal filed in January 2021, DOB audited the job to add the oil change shop and subsequently revoked the permit since the professionally certified plans did not show the reservoir spaces. The permit holder submitted amended plans showing 10 reservoir spaces, which were accepted in June 2021. On August 8th, 2022, a DOB inspector inspected the premises and observed that there were obstructions, such as lighting, signage, and canopy posts that prevented the premises from providing the required 10 reservoir spaces. The instructor issued a summons returnable at oath for failure to conform to approved construction documents and amendments. On September 1st, 2022, another DOB inspector performed a follow-up inspection and confirmed that the obstructions were still present. 2 zoning violations returnable at oath were issued, one for failure to provide 10 reservoir spaces because the built conditions did not match the plans, and the other violation was for performing preparatory work in the reservoir space. On October 14, 2022, the department approved amended plans with dimensions that matched an updated survey dated September 27, 2022. The plan examiner found that the plans clearly showed the obstructions to be removed, and that after the removal of the obstructions, the dimensions indicate that there is room for 10 reservoir spaces, each no less than 18 feet long and 8 feet 6 inches wide, consistent with the minimum dimensions set forth for reservoir spaces in section 13-25. The oil change shop is proposed to be located adjacent to the 10 reservoir spaces and does not decrease the reservoir spaces, so there will not be a non-compliance as alleged by appellant. And as pointed out already, the department requested that the permit holder add a note to the plans stating, quote, "No washing or other preparatory activity permitted in the reservoir space. All washing and preparatory activity must be done in enclosed space as per section 32-41 and 32-412. And actually, I also just want to add in response to a question that was posed earlier, the November permit was based on the last set of the permit pulled in November 2022 was based on the last set of plans approved in November with the added note. But those plans were the same as the plans approved in October. It was the only difference was the added note. But the permit was pulled based on the last set of approved plans. So lastly, it is the department's position that the appellant's claims are not based on the approved amended plans. The appellant has submitted memoranda from Equity Engineering providing traffic observations made during the pendency of the appellant's appeals, which conclude that there are not 10 reservoir spaces available at the premises. However, the observations were made when there were obstructions present. The applicant has revised their plans to show the obstructions will be removed, which will result in there being 10 reservoir spaces available. The appellant asserts that the permit holder is conducting preparatory work in 2 of the reservoir spaces. As previously stated, the department has taken enforcement action by issuing an administrative summons ordering the permit holder to discontinue all preparatory work within the reservoir spaces. And all preparatory work must be located within a completely enclosed building pursuant to zoning resolution section 32-412. To obtain an amended certificate of occupancy, there must be a final construction inspection to confirm that the completed work matches the approved plans. Significantly, there cannot be any open violations on the premises. If at the time of the final inspection, the conditions are not in compliance with the zoning resolution and other applicable laws, the job will not be signed off, no amended certificate of occupancy will be issued, and the permit holder will continue to receive violations. Accordingly, the department's determination to approve the job is proper. The department respectfully requests that the board affirm the department's issuance of the permit. And then I do have some other points in response to questions and issues that were raised. In response to Commissioner Yoon's question about whether the Department of Buildings examined how cars would enter and exit the oil change shop, I spoke with the plan examiner, and we were initially focused on whether there were 10 reservoir spaces present. He looked at the plans again while we were, on the phone. In the approved plans show that they can enter and exit the oil change shop using a curb cut on Coney Island Avenue. However, the plans do show that there's a pass-through for them to exit on Avenue C, but right now they cannot actually exit on Avenue C. So we will be asking them to amend the plans. They will either need to close the pass-through or add a curb cut on Avenue C. We do not expect it will affect the job approval, but we will be asking them to amend the plans to show how the cars will be exiting from the oil change shop. Something else, in terms of the maneuverability issue, actually, I found the permit holders submitted a video that I found very compelling, which shows the car wash and the reservoir spaces and cars entering. And I know the plan examiner also looked at it, but I'm just adding that I think the permit holder's video shows that the setup can work and does work in real life. And it does, as was shown by the traffic experts photos, it does appear that they have actually already removed the obstructions, but they haven't certified compliance yet. So I just want to make that statement. In terms of Natcha v. Klein, that's the one case that addresses reservoir spaces and which went to the Court of Appeals. And the Court of Appeals had upheld that the Department of Buildings requirement that the cars be in a line of, that the reservoir spaces had to be in a line of traffic was not arbitrary and capricious. But actually the department has changed their position since that case in the 70s, because the zoning resolution does not explicitly state or give any required configuration. So we don't follow it anymore. We are not requiring that the reservoir spaces be in a line of traffic as was required by the commissioner at the time. We just are requiring that they be on the zoning lot. So just to clarify, we're no longer following that case because it's not explicitly a requirement in the zoning resolution text. And then lastly, in response to Chairperson Shanda's question about requiring a restrictive declaration, we don't understand what the restrictive declaration would require, and we don't really see a need because they're already required to legally comply with the zoning resolution. So we just are not clear as to what in addition we would be asking them to.
Okay. Do you have any more to state? Because then I can open the floor for questions.
That's it. Thank you.
Okay. So my question with regards to the restrictive deck or similar kind of document specific is that there is the component of what's on the plan and that what's on the plan has to comply with the zoning regulation and the way the DOB interprets the zoning regulation in its review of the plan. Then the second part of it is executing that plan. And the execution of the plan, a lot of it is dependent on the operation of the plan. And the photos and the videos that's been provided show that the operation of the plan also was a critical component to making the plan as physically shown on the sheets of work. And so my question was, does DOB have any mechanism by which they require the permit holder to maintain a certain operational level or operational features that, for example, in this case, the owner's traffic engineer, Mehdi Amjadi, stated that there seemed to be like 4 sets of attendants who were there to move the car from Avenue C frontage onto the reservoir space, from there to the staging area, from there to the cleaning part, and then from there to the car wash. So there were 4 sets of attendants with 4 distinct tasks that was helping it move this row in the most efficient way. So is that something that the DOB then conditions, and so you need to maintain that in order for this to also work, or that's something not within the purview? Or it would be at the end, it's like, oh, it's not working, and therefore I'm going to issue a violation, and it's up to the operator to figure out the operational process to comply.
So actually, we have discussed the part, requiring parking attendants, and we don't feel that there is any that we actually are authorized to require them. It's not a requirement in the zoning resolution, so we don't think that we can require, or that would be appropriate for us to require the applicant to continue having the parking attendants. But we would, we will continue enforcement efforts, and we think that the mechanism would be through violations and continuing to violate the permit holder if they continue doing work in the preparatory area.
I do have, thank you. That's for that clarification. I do have one question. You did say that the applicant has to come back for a certificate of inspection. Now, is there a time frame within which the applicant has to seek that request, or can it has to be, that certificate of inspection has to be done within 2 years time frame or within a year time frame? And should they fail, then does DOB come in and say, you haven't done so, and we are therefore going to revoke it? My reason for asking that question is, can then the permit holder just sit on not making this official request to DOB because they, for various reasons, the site may not be ready, and therefore not seeking the certificate. Meanwhile, the operation is happening in not in a fully compliant manner. And how long can that interim interim period be? Is there a bookend to it?
I have to, that is an excellent question. I have to look into it and
Okay.
double check. I'm not sure.
Okay. Yeah. I mean, I think DOB is doing an excellent job of staying on top of it and monitoring it. And if let's say there are little infringements and these are causing these delays, are these purposeful delays, or are these delays that is really because of site issues? And can those delays be expedited so that the site can operate in full compliance in the most expeditious manner, which is what DOB wants? And how do you ensure that? That's really what I'm trying to get at. So,
Chair?
okay, yes, Commissioner Shetta?
Yeah, I just need some clarification on what is mentioned by the DOB council. I thought Ms. Rosengold mentioned something about the like the oil change exit, and there is a possibility that a car that's done with the oil change go out to Avenue C. Is this exit was planned to be through the storage or the reservoir space, and that's why you're asking them to modify these plans and resubmit them?
No, we would just be asking them to modify it because right now it's not workable. I mean, it's showing a pass through onto Avenue C, but the only way would be, I guess the only way would would be if they were to go on the reservoir space, which was not what we were expecting them to ever be doing. I think it was just an oversight that we didn't realize that there was a pass through that essentially leads to no other curb cut on Avenue C except the one for the reservoir space that we don't want, that we were not expecting them to be using. So that's why we would be asking them to either close that curb cut or add another curb cut. But there was never the expectation that they would be going through the reservoir space. We were looking at that as a distinctly separate area.
So if I seem to, sorry, go ahead, Commissioner
And
Shetta.
this kind of plan was not approved by DOB. Do we have a copy of this plan in our records?
I think we have.
I haven't seen any plan showing.
No, we just,
like
yeah.
a maneuverability plan or something like that. If we don't have it, if you can please submit it. And after it is submitted, we need to get the copy of the updated plan that shows that there is no exit through the reservoir spaces. Because this is for me, this is very vital to the definition of the reservoir spaces. If you're utilizing this area for something else, I would look at it from a different perspective. It's not solely dedicated to be a reservoir space, 10 spaces. But if it is just used for storage of vehicles awaiting car wash, I believe we're done with this appeal.
Yeah, you know what? I have a feeling there is a little bit of a misinformation that is flowing right now, because way I understand the owner can explain this in terms of how they're proposing to operate the oil change in relation to. My understanding was that anyone who goes to the oil change has to go into the car wash zone, and that means the vehicle that enters the oil change shop then comes out facing Avenue C, but not exiting onto Avenue C, and then merging through the site onto one of the 10 reservoir spaces, and then go through the car wash. So at no time will the car be stepping out of the property onto Avenue C, or at no time will the car be stepping out of the oil change and going through the reservoir space to get onto Avenue C. Because the whole package deal is that it has to go through the car wash.
Because
one way DOB can ensure that there's no such thing will happen is you put a wall around that entire corner of Avenue C and Avenue. But that I'm not going to tell DOB what to do. You know better than I do. But that's my understanding. So maybe this is definitely something that is not closed, and for DOB to look into with the applicant to make sure it meets the permit and meets the requirement of the zoning regulation, which is what the DOB would be looking for. Any other questions?
I would take that just if every single car that's going to the oil change is going to be going to a car wash. But if this is not the case, and a car is coming from the oil change area out to the reservoir space, I'm not sure what's going to be done for this car if it's not going to a wash. And is the deal coming like a bundle? Oil change and wash?
It's a bundle. It's a bundle. That's what the appellant letter says. It's a bundle.
Okay.
You go for the oil change, and then you must go through the car wash. And it's the attendant takes the car wash, does the oil change, and the attendant takes that car into the reservoir space.
I got it. The reason I thought a different way, because DOB mentioned that they are asking them to
so I think there's a little bit of a communication going on, Ms. Gould, and you may want to discuss this further with the plan reviewer and the permit holder, and ensure that it's in compliance, because that is what the appellant is stating is. I think what the appellant is wishing for is moving all the queuing from Avenue C and onto Coney Island, and this was a missed opportunity should this shop be opened up on Coney Island. But anyway, any other questions for Ms. Gould? Then if not, I want to open this. Okay, Mr. Schenker, am I
Yes.
pronouncing your last name properly?
Yes, thank you, Commissioner. I need to ask that my expert received an invitation. He's watching this. Maybe Amjadi, and also the owner also registered. The operator of the car wash has not been sent the invitation to join.
Oh,
They're watching
okay.
this. They registered.
What is his
but they-
name? Mehdi
Mehdi?
Anjadi?
Mehdi Amjadi.
And can you join us? And what's the other person's name, Mr. Schenker?
It should be Kim,
Kim.
Monkey Kim.
Oh, Monkey Kim. Okay. Can you both of you join us panelists? Steve? You have them in? Okay.
Yes, I see Maddie.
Mr. Kim and Mr. Amjadi, could you please unmute? Or present yourselves in photo and visual if you can.
Yes.
Okay. Okay, thank you. Mr. Kim? Mr. Schenker, if they're not going to speak right now, you could proceed or.
Okay. Okay. So I will try to, I will try to answer some of the questions so that I jotted down that people had, and also address, I'll just address the issue of the vehicles exiting the oil change. The reason why there is no other curb cut on the plan, and I discussed this with Ms. Rosengold a little over a year ago in emails, and I have copies of the emails, and also with several plans examiners. So this issue was discussed. The vehicles from the oil change, after they leave the oil change, the attendant takes them and takes them to the reservoir area to join the reservoir area and the car wash and the stream of traffic that goes into the car wash lane. They cannot exit anywhere, and the owner of the vehicle picks up the vehicle after he leaves it off for an oil change at the exit from the car wash. So the price of the oil change will be included. I'm sorry, the price of the oil change will include the price of the car wash, and the vehicle owners simply, just by insurance requirements, we can't allow them to stroll around in the oil change area. So they'll be waiting at the entrance from the car wash, and they will be picking up their vehicles after the oil change is done. The vehicle is moved to the car wash lane, is washed, and then is given back just like any other car wash, any other vehicle that enters from Avenue C for the car wash. And the reason why I mentioned Nachev case, because we have to show that we have enough space for 10-car reservoir, not more. Given the end, we have to show that we're able to maneuver the vehicles without leaving the zoning lot. If there are vehicles that come from Coney Island to have their car washed, the mere fact that there is an interest step of having an oil change actually qualifies all the area in front of the car wash as additional reservoir space. So because they will eventually go into the car wash. So we have one of the largest zoning lots dedicated to the car wash operation in Brooklyn. We have enough space up front. If
Mr. Schenker, you're breaking up.
Yes.
Mr.
I apologize.
Okay.
What I'm saying is, yes, can you hear me?
Yes.
Yes.
Can you hear me?
Yes.
What I'm saying is that the oil change, if you place the oil change, the vehicles, that operation will not detract from the space that already has enough reservoir space in front of the car wash. It may only count as additional because the vehicles will travel from the oil change to the car wash. So the space in front of the oil change can act as additional space for the reservoir. Okay. So that's why we don't have any other curb cuts. To the extent appellant raised an issue that there is an illegal curb cut at the corner of Avenue C and Coney Island, we don't plan to use it. If the DT wants to close it, fine. If the DB wants to us to require to close it, fine. If the DB wants us to add a curb cut somewhere, fine. I mean, we're not planning, but we're in compliance. Well, you know, this application has been in audit for a year and a half. That we had so many, and we didn't have a problem before. You know, the current complainant started complaining, and we've been through so many different inspections that we're in compliance. You know, if they feel that in the future we will not be using it the space as intended, it's a matter of enforcement. It's not a matter of existence of space for 10-car reservoir as per the zoning resolution. And also, with regard to the top front vehicles, the prep work, I have a video that shows that the vacuum in the prep work actually occurs later inside its closed space, and I can show this video to you if you allow me. I can share the screen and show the video, but I have the video which I personally took that you have, and I can play that video as well. There was 10 vehicles, and they were traveling in the flow of traffic from the street into the car wash. With regard to the greasing of the wheels and window, washing, that always happens after the car wash. You wash the vehicles after the initial tube car wash, automatic car wash. If there is anything left remaining on the window, that's done after the car wash. The greasing of the wheels always happens after the car wash, because you don't put in the grease then wash it away in the tube. It just doesn't work. That it loses the shine. So that's the end touches. And so and I'm ready to give it to the man of the hour, Mr. Mahdi Amjadi, who was at the site, who can answer any of your questions. He was a traffic engineer with substantial experience, and I would pass the baton to him.
Hey. Good afternoon, Madam Chair and Commissioners. Yeah, I just
Please state your, I'm sorry to interrupt you. Please state your name for the record officially.
Yeah, my name is Mahdi Amjadi.
Okay. You're the traffic engineer?
Yes. I was hired by the property owner of 664 Coney Island Avenue to car wash and oil change facility to review traffic report prepared by Equity Environmental Engineering firm. I have the following area to cover. Maybe that would respond to some of the questions that came up before. The most important thing is that we have to. I want to tell everybody that DOB is an expert agency, and they have engineers and planners that are expert to examine queuing, reservoir area adequacy, and car wash reservoir area, and then the maneuvering of the cars in the reservoir area. So that is, we concur with that that decision and approval, and you have to make a note that this is the agencies, they look at these things from every angle. So this is not fair to come out and say that this part of the plan is not adequate, something suspicious is going on. Plan is being certified by DOB, Department of Building, has measurements, and the measurements indicates adequately that we have more than enough reservoir space. I can go through some of the calculation here. We have 61 feet from the property line to the structure. That's shown clearly on a site plan. that are approved by DOB, 37 feet wall to wall for the width of this reservoir area that ends up to be about a little bit over 2,000 square feet of reservoir area. We only need 1,500 square feet for reservoir area. So the remaining is an area that cars can maneuver, or that we, as we have seen in the pictures that I have sent. I've taken when I was surveying the site. They have two parking attendant, and they direct the traffic to come to the site, to the reservoir area, and then there's another attendant that there is providing direction for the cars to come in to the cleaning area, vacuuming area, which is not part of the reservoir area, is separate as before you get to the tunnel. So the fact that we don't have enough room for maneuverability, and then also not enough room for reservoir area, is you can only check that by looking at the site plan and see what the areas, what the reservoir areas is, and then if is that adequate or not. And we can see from the site plan that approved that 10 reservoir area, 10 cars reservoir area exists or is there, and is from my pictures it shows that is working properly. Now in terms of oil, the other area is that some from the site plan, I don't know if the equity has looked at the approved site plan, but the measurements are all incorrect. For instance, they measured the length of the reservoir area 49 feet, which is not which is not the case. Is clearly says 61 and 2.5 inches. So I just want to, because this question came up a lot about the reservoir space and if there's the room for cars to maneuver. We have all that, and the oil change, the way we explain it in the report, that is in a price structure, is that you pay for the car wash. You come in from the avenue, Coney Island Avenue. You wait in that area. You get to the oil change. It takes about 10 to 15 minutes to get to finish, and then the attendant brings, as they take it for the oil change, they take it also to the car wash area. There's no exit from car oil change to the Avenue C, and we can make sure that that's not the case, because it's not going to work for you got to understand, this is a business. If it's not working for the business, from engineering point, it doesn't work, and in terms of business application is not working either. And the other thing that I want to add is that the applicant is willing to provide more staff to direct the traffic and direct the traffic to the tunnel, because this works for him, because he makes more money, he makes more applicant to come for car wash and then oil change. So this, building department can give us some guidance on that, but I'm pretty sure that the applicant is the car wash owner is going to provide that, because it works for him. All right, so some measurements I said I looked at the plan. Mr. Becker said that the curb cut is within the 50 feet on Avenue C. That's not correct. the site plan indicates is about 60 feet. And on Coney Island Avenue is about over 100, to be exact, is 163 feet from the corner. So that's not a violation anyway. Now, now we go for I went for the site visit, which was Wednesday, February 8th, 2003. And I was just looking at the site with this approval, with approved site plans. You know, I'm just basing it on that. I don't go before that because I don't know anything about operation before that. I just looked at it that day, and I looked at this site plan that is approved. And from engineering point, it is, in my opinion, it was working properly. And so I did the site visit, and I can explain the operation when I did the site visit. So I did a site visit at our car wash, giant car wash and oil change facility from 11 to 1 p.m. I did the observation. I measured the time for cars going in the vacuum area and then car wash. And it took like between 1 minute and 1.5 minutes. Just remember this, because if you have a busy day, you can you can set the car wash for the faster speeds. If you are not, you don't have a busy day, you can leave it for lower speeds. Now, but that day, a car wash was set up for 50 cars per hour. So I observed about between 40 or 45 cars. And with that amount cars during that peak hour, it was working properly. I didn't see any car queuing on Avenue C, maybe one or two. And then that's by having the attendant bringing all the cars in, it disappeared in no time. Now, for this car wash, I observed that cars are coming in. Car wash attendant bringing the cars in, and then while they're giving the tickets for the services, and then another attendant before the car goes to the tunnel, directing the traffic to first time, first serve. They come in and they go into the tunnel to the area for the vacuuming and the cleaning. So I just want to say that from engineering point of view, I think that adding the oil change, it is not, those areas doesn't count as a more reservoir area for the car wash, but it would help the car wash to operate much better. Why? Because you're coming through the car oil change. That's like a meter, you kind of control the flow. They go into the oil change and they have 10 minutes to 15 minutes to get the oil change. So that gives the attendant to sit there and then come in and then bring everything to the car wash reservoir area. So it helps, because some of these people that are right now, they come into the car wash, they're gonna do the oil change in the future, because that service is provided by this facility. So some of this patrons is going to show up on the other side, that we have more room for more room for waiting and all that. I think that, in my opinion, the queuing, if there is any queuing, is going to go away by having that. It's not going to add any more reservoir area, but it makes the operation go smoothly. Now, for when we had this, I was at the same time when I finished looking at this car wash or surveying, I said, let me look at another example in the area to see how the other car wash operates in the area. So there is a car wash, it's called Hollywood Car Wash and Oil Change, similar uses, similar operation within half a mile radius on Coney Island. The same exact kind of operation. So I went there and took some pictures. The reservoir area I believe the reservoir area in that Hollywood Car Wash is not enough, because I have seen the car queuing. I have some pictures that I provided in my report. Cars that are queuing in the designated bus line on bus lane on Church Street, up to 15 cars. That's how much I can see. But
Mr. Amjadi,
yes.
Question. The example that you're citing,
Yeah.
does that have any bearing with the case that the subject cite?
No, I just want to, when you.
If it does not,
observation is just, I made an observation to see if our car wash is making too much queuing on Avenue C, which is less traffic than Church Avenue, and then if it's a safety issue. And I wanted to see if there's a safety issue that we can acknowledge that and try to correct it. So I look at this sample, similar operation, and I see that they have like 20 cars on the street on designated bus lane and car standing on the sidewalk, which is safety issue.
Let's, because we
in
have
comparison, yeah, I'm sorry.
Let's just focus on the subject side. Let's not
Yeah.
talk about other sites.
Okay, so that's just a comparison. But at the end, I just want to say that, there was some also comments about the some comment on the report that Equity provided. They show some pictures on their reports that doesn't show that there's a queuing on the street. They don't even show that the difference between cars going into the parking, the reservoir area, or the cars going through the intersection, through traffic. So I didn't think that was very supportive of what they're trying to say. I talk about measurements which weren't correct based on the site plan that we have, approved site plan, and also the other thing that it was not. It was also took my attention was that they looked at the service time, they measured service time at the site, but they didn't measure the time for how many cars going through, so they can discuss that. They look at ITE rates for the trip generation, which I looked at it, and that particular use is a sample size is so small. That's not kosher to use that for the trip generation. So that's all my observation from this car wash on behalf of my property owner, 664 Coney Island Avenue.
Thank you, Mr. Amjadi.
Thank you.
I see a lot of hands are up.
Yep.
So I'm going to start with before Mr. Kim, states anything. I believe DOB and Mr. Becker and Commissioner Sheta and followed by Mr. Williams had some questions.
Okay.
So let me ask them. Let me start with DOB, Ms. Gould.
Oh, I had just wanted to clarify, it was a while ago, but I think Commissioner Sheta was, I think maybe I misunderstood, but I think he said that he hadn't seen the plans for the oil change shop. And I wanted to make clear that the plans that we were looking at with the reservoir spaces are for the oil change shop job. That said, we are going to be reaching out to the applicant and asking them to amend regarding the exit, closing the see-through,
Avenue C.
I'm sorry? Oh,
I'm sorry.
Openings that show they would be exiting.
No, there won't be. I think Ms. Gould, the question, they will not be exiting onto Avenue C.
Yes, so we're going to be asking them to close. On the plans, they have openings for the building.
Okay.
For the-
I leave that up to you. This is not for us, but yeah.
Okay, so in any event, we will submit the amended, when we receive amended plans, we will submit the revised amended plans.
I saw the plan you mentioned, and my question wasn't related to the plans of the oil change itself. I thought what you mentioned is that you have a maneuverability plan showing cars moving from the oil change to the reservoir space, and that's why I asked to get these plans. If they do not exist, then my question is moot. Thank you.
Not that I am aware of. These were the plans. I was just saying we never anticipated that as far as I know, we did not anticipate that they would be going through the reservoir spaces. But just the plans do need to be amended to show that there are openings for them to go to Avenue C. Okay. That should not, I don't think, should exist.
It's just open. It's not a
or
thank you.
Perhaps, I'm sorry.
Go ahead, Ms. Gould. Why didn't you finish?
Oh, I was going to say perhaps they don't have to close them. Maybe they want to put in some sort of turn to be able to turn into the reservoir spaces. If that, if they're going to be going to, they're going to be going for the car wash after the oil change. So perhaps it would actually make sense. Maybe they keep the spaces open and they can just turn into the reservoir space area.
Right, which is my understanding is what the applicant, the owner is proposing to do. But I think that's a discussion that you need to have with the permit holder and revise the plans accordingly as you see fit. I know Mr. Kim wants to speak and he's part of the owner's team. I want Mr. Becker and Mr. Williams. Do you want to wait for him to finish and then you want to state your question, or is your question specific to Mr. Amjadi's?
My response is specific to Mr. Amjadi.
Okay, go ahead.
So there are a few issues. Twice in Mr. Amjadi's statement prior on the record and when he was speaking, he talked about a staging area, to quote him, and then he said you get to an area before you enter the tunnel. Now, if I don't question the 61-foot dimension, if you have 3 rows of reservoir space, that's 54 feet at 3 times 18, which therefore leaves all of 7 feet for staging area, which is not staging area. It doesn't allow for a full car. And we go back to the issue of doing preparatory work in the reservoir area. There's been a claim, and I've never seen this in a car wash in my entire life, and I've been using them for at least going through them since I was a child, way too long ago. Once a car gets in the tunnel, it usually gets onto a track, and that's the end of it. There's no time, no space for vacuuming or any other preparatory work. So I question whether or not everything, in fact, is not occurring outside in the reservoir area, since he mentioned twice going into the staging area. With regard to the curb cut, I was referring to a curb cut which exists directly on the corner of Avenue C, literally at the corner on Coney Island Avenue, on the Coney Island Avenue frontage. And with regard to any other curb cut, it would be within 50 feet of a corner, which is my understanding is not permitted. So that was my comment about the curb cut. But again, the staging area, again, goes to my argument that preparatory work, staging work is being done within the 10-car reservoir space based on the physical dimensions.
Okay. Mr. Williams, thank you. Mr. Becker?
Yeah, so I just simply wanted to correct the record. First of all, it's clearly noted in my report in multiple areas that 62 feet is the area from the curb to the edge of the building. However, as the plan submitted at that time, there was a canopy where staging was done. The effectiveness goes right back to what Fred said. The effective area was 49 feet. So Mr. Amjadi observed the condition after 30 years of operation that had been cured in the last month. And that is what it is. The second thing I wanted to point is, as I pulled up not only Mr. Amjadi's photos, but as is littered throughout my report, are photos showing 5, 6, 7 cars queuing out onto Avenue C. I have not seen the videos that Mr. Amjadi prepared. They were not submitted or provided to me. However, I did show the pictures that showed queuing going out into the street. The fact that my report does not demonstrate this is false. And then the last thing I wanted to note is the use of the ITE manual. So Mr. Amjadi provided no such traffic generation analysis. And I'm sure, as a person I worked with for 10 years while he was at Environmental Assessment Review Division, and somebody who's intimately familiar with traffic generation factors, you're aware that the ITE manual dramatically understates traffic generation in New York City. So what I'm doing is providing a much less amount of trip generation actually that this operation generates. And there are 3 of them on the ITE manual, and I used the lowest one that was presented. And along with that, so we timed runs. I don't know if you took your car through the car wash, but I did, as well as my staff did, multiple times to establish the service rate. And then we used the very fair ITE manual as applied to New York City and ran the queuing, which of course disastrously falls apart, as is shown in my quantitative analysis. But I just wanted to correct the record. None of this is really of a matter. All of the photos that I've seen show that the site cannot operationally handle 8-car queue. It only has space for 8 cars. All of the photos shown from Mr. Amjadi show 8 cars. Be happy to review the video and confirm DOB's statement that it functions just fine. And maybe that's the case, but I will note Mr. Amjadi indicated there are 6 individuals in the queuing area. When I went through the run, there was 1 individual there present, which begs the kind of question that the chair indicated, that apparently we're going to wait for problems to occur and for cars to back up. And there have been multiple traffic accidents at this intersection. If you look at Vision Zero, apparently we're going to wait for more traffic congestion and issues to occur before we attempt to cure what are the clear operational defects at the site. I'm not saying there haven't been good measures taken to date. DOB, I think, did an excellent job of curing a lot of the things that were noted in our traffic study. And I'm not saying that did not occur. I do want to however, note the sort of blanket statement that was made in Mr. Amjadi's report that this is going to function better because of the oil change. It's just, there's just simply no basis in reality for that. We have cars that are going to come out, whether it's 15 minutes at a time, 8 minutes at a time, 10 minutes, 13 minutes. They're going to be queuing from that oil operation, vying for space, and presumably the peaks will be the same. So we're going to have peak traffic coming out of the oil operation, and we're going to have peak traffic going into the queuing. We're going to be hitting with 2 cars queuing into what's already a very limited space. You're going to have spillback for cars waiting to get into the queue line. So I just want to give my thoughts on that as well. I find that operationally to be very unsatisfactory, and you're forcing, I mean, customers want to be forced through a car wash in their car, then so be it. But that's obviously, attempt to cure defects at the site plan. But that's all I wanted to remark on.
Okay, thank you. This is turning out to be more of a traffic analysis review of a project that we would do if we had a special permit or a variance, but that's not what this is. This is an appeals case with regards to a zoning interpretation. And so I want to hear Mr. Manki Kim.
Yes,
Am I
Manki
your
Kim.
name? Yes.
Manki Kim.
Manki Kim. Thank you.
Manki Kim. K-I-M.
Sorry.
Yeah, Kim,
Sorry.
yeah.
Sorry.
And
Please go
I'm
ahead.
with my our manager, Sikuna Turi. We are together, and I've been running this business for the last 8.5 years. And I like to mention about a few things. Number one, oil change. Any customer who has oil change service is going to car wash side, because customer with oil change has free car wash. That's the bundle, as you said. That's why no car is exiting Avenue C. Every car, oil change car is coming to car wash side. That's why no car is exiting Avenue C. At the same time, after oil change, we have reservoir area. We have space. After oil change, car can stay reservoir area. That's one thing I like to mention. Number two is, I think Mr. Becker told me that prep works going on area. That's true. I am here every day, 365 days if we don't have snow, rain. I'm here every day. We done prep works in closed area starting from February, because we got final approval last year, 2022 November, and we did some construction works in order to abide by DOB's approval. We never done prep works in the reservoir area. That's what I want to mention about. Number three is Mr. Williams mentioned about some artificial construction fence, those kind of things. That's not the case. We've done everything based on approval by DOB November 2022. And also, we have designated traffic controller. As you can see, last photo my representative provided. We have traffic controller, he's controlling all the traffic. That's why in that sense, I don't think there is any issue on that. And last one I like to mention about is Mr. Williams talking about some picture, but that picture was taken long time ago, before final approval November 2022. That's why that picture is the old picture. That's not new picture. That's I like to mention about. At the same time, if you have any question to me or my manager, and I'm happy to answer the question.
Thank you. First of all, commissioners, do you have any questions for Mr. Kim? Okay. I saw Mr. Amjadi raise his hand, not a virtual, physical one. Okay.
Yeah.
Go ahead.
I'm sorry. I just want to respond to 2 points that Mr. Baker brought up. One is the staging area. Staging area is not part of a reservoir area. That's clearly shown in the site plan. Now, you talking about the staging area I'm talking about the structure and the property line. That's 3 times 18 is 54. We have 61 to work with, not the staging area. A staging area is beyond that 61 feet. So that's in a covered area.
So just to help everybody understand this, when I'm looking at the plan, the November 1st, 2022 approved plan, I see the site dimension with 10 reservoir spaces, dimension of 54 feet, and then from 54 feet to the wall of the structure, which is 3 foot 9.5 plus 3 foot 9 inches. That takes you to the 61 foot dimension, is where the start of the building is. And then within this plan, it shows a dashed area much further into the site, which says start line. So is the start line is where exactly the conveyor, as I call it, the conveyor belt of the car wash is starting. So between that wall where the drawing says replacement of roll-up gate to the dash line, is that the staging area?
I believe, can we put the map on, the site plan on?
I'm
Because
going to ask Commissioner Sheta.
I'm sorry, I don't have that.
If you can use the plans that, yes. So
Yeah.
I'm referring to the staging, yes, where the arrow is. Commissioner Sheta,
Yeah.
if you can take the arrow.
This is
yes.
I'm sorry, this is the start of the conveyor. This is the area of the staging area, this area.
Okay. So that
from
is
what I
within-
understand.
That
Yeah,
is
had nothing to
within-
do with the reservoir area.
Okay.
I'm sorry?
Thank you for that clarification.
Yeah.
Okay.
So the staging area in that area I just showed. And with the other question that Mr. Baker reminded us, I apologize. I thought you're referring to the curb site that is for reservoir area. There is an existing, all these curb cuts are existing, and we are not trying to change or alter them. If there's a curb cut that we're not going to use it in the future, as we said that from the oil change, nobody can exit either from that curb cut that Mr. Beck is referring to, which is within 50 feet of the intersection. That's the existing curb cut. We are not providing that curb cuts. We are not proposing that curb cut. I was trying to, yeah.
Go ahead. I want to wrap this up. We have been at this for nearly 2 hours.
Yeah.
So what
I only have one more answer to Mr. Williams. The reason why I said about ITE rates, I looked at the ITE rates that you provide.
Mr. Amjadi, I'm going to stop you right now. I'm going to stop you right now, please. I don't think, in the interest of time, we have spent 2 hours, and there are a couple of questions that are still, that needs to be looked at both by DOT and by Mr. Williams and by your team to look at everything and go back and respond to. So I think you can use that opportunity to rebut what Mr. Williams said, and Mr. Williams, you can rebut what Mr. Amjadi said, and vice versa for DOB also. We have lots of cases, and we haven't even started the discussion. So,
Commissioner Chander, if I may, with regard to the staging area, this is Mikhail Schenker, the attorney for the car wash.
Right, yes.
I have the video that shows the area identified on the plan that you pointed to. That's where we do the vacuuming.
Okay, please submit it in your next submission. So we are not going to close this now. So I'm going to ask all of you to provide a submission. And I think it has to be done in a sequence. First, the appellant has to provide a response. And I believe after that, the DOB and owner provides the response, and then appellant has an opportunity to rebut and provide a response. So that will be the sequence. And our project manager will coordinate with you as to the sequencing of these submissions, and the next hearing date will be scheduled based on that. Anybody from any other questions for the appellant team, for DOB, and for the property owner from the commissioners? No. Okay, let's go to the public. Thank you. I really do appreciate
Thank you so
all
much.
your participation in this. Well, hold on, we have to go to the public.
Okay. The case we are currently discussing is 2022-16A, 664 Coney Island Avenue, Brooklyn. This is an administrative appeal. Should you wish to discuss, dial 646-558-8656, or outside the city, our toll-free number is 888-475-4499. You will enter webinar ID number 897-1392-1890 and press the pound sign. At the next prompt, you will press the pound sign. Once you are permitted in, you will press *9 to raise your hand to speak, *6 to unmute to be able to speak. And if you're in the Zoom room already and wish to speak on this matter on Coney Island Avenue only, you please raise your Zoom hand, which is the small hand that is the bottom of your computer screen. Once you are permitted in, you will have 3 minutes to place your comments.
Okay, so while we are waiting for the public to call in, Mr. Becker, how long will it take you to provide a response?
I think I would like a minimum of 1 month. I have to coordinate with Mr. Williams, et cetera. So I would say at least 1 month to provide a response, at least, maybe.
Okay.
Yes.
Okay,
So
thank
we're
you.
talking beginning of April.
Okay. All right.
Actually, well, how we can submit, right? Sorry, go ahead.
Yeah. Okay. So beginning of April, Ms. Gould, how long will it take for DOB to for you to respond?
I think if 2 weeks is acceptable, I think that would be appropriate. Although I do want to point out, I think there's a holiday. I mean, I know that there's a holiday in April.
Right, those first 2 weeks, the 5th to the following week.
Okay. Okay.
So based on that, I'm not sure if I don't want to push it by saying perhaps.
Right. Let's aim for
3 weeks.
then April 10th or something like that.
No, that's in the middle of the holiday. That's right in
Oh,
the
that
middle
is
of.
middle of. So then you're
The
looking
holiday
at,
starts on the 5th, the 6th and 7th are holy days, and then you have the following 13th and 14th are holy days. So it would be the following week that would make the most
Okay.
sense.
So
for Ms.
April 17th.
Rosengold,
Okay.
like April 21st or something. Give
That
her
would be
time.
great.
Okay. So it would be April 21st for DOB to submit. Okay. Owners representative, Mr. Shankar, I think you probably have the same time period. You by 21st, you can also submit.
I need 2 weeks after the end of Passover.
And
Because
when
I-
does
I will-
Passover end? When does Passover end?
April 13th. So I need until April 27th.
Okay, so I would say both DOB and owners representative, you submit by April 27th.
When is Mr. Becker submitting?
April 3rd.
April 3rd, Fred?
Yes.
Okay. Okay.
And April 27th, DOB and owners, and then there's a reply.
That's
Right?
right.
Yeah.
So then that would be like May 8th maybe, or
Yeah,
how long do you need, Mr. Becker, for a reply?
I would say at least, Kevin, is 2 weeks enough, or you prefer 3? You're nodding and muted.
That's fine, Fred.
What's it, two or
weeks
three?
is- 2 weeks is fine.
So it'd be about the 10th then, right?
Right, so we're looking at May 11th.
Fine.
I'm sorry, what is the date?
May
No,
11th,
it's-
my response,
yeah.
my response.
May 11th is for Mr. Becker to provide a reply to the comments that would be submitted by both DOB and by the owner. And then we won't take any more submissions. The hearing will be scheduled based on after May 11th.
And then may
So
I
maybe
ask
2 weeks after that, yeah.
one quick question? Fred, did we receive the videos that were referenced by?
I was just going to say, so I think you all need to share each other's videos and photos. I think whatever has been submitted to us, please make sure, both for Mr. Becker and for Mr. Schenker, whatever documents you're sharing with BSA, please share that with DOB and also with Mr. Becker, Mr. Schenker, respectively.
Of course.
Those were shared, yes.
Okay. Did you want to set, Madam Chair, did you want to set the hearing date? For,
If it's 11, then I think the next hearing date will have to be 22nd, 23rd. And I don't have the calendar in front of me fully to know.
May 22nd and 23rd are the next hearing date, the hearing dates after the 10th.
Yeah,
So, or unless you'd move it to the 5th or 6th, but
yeah, I cannot see the schedule for May 22nd. I think so far it seems doable, but I don't want to commit to it, but most likely it'll be May 22nd, 23rd. We will confirm very soon.
okay.
Okay, I really appreciate all your dedication and participation and so much information that you have shared. Thank you all.
Thank you very much
very
for your
much.
courtesy and patience.
Okay,
Thank you.
thank you. Question for
Ma'am-
the commissioners. Do you want to take a 30-minute break for lunch and then resume with all the other cases? 30 or 45 or 40?
30 sounds good, since we have a full afternoon.
Okay.
Okay,
All
so
right.
we'll resume at, this is 2:01, so like 2:31, 2:32?
Yep.
Okay,
32 precisely.
okay. So we'll resume at 2:32. Are we good?
Yeah,
Okay, we have a quorum. Do we want to start, Madam Chair?
yes, let's start.
Okay, Steve, do you want to put up the screen again, please? Thank you. Okay, we're back on the record. This is the Board of Standards and Appeals public hearing for February 27th, 2023. The next item up is SOC calendar 245 32 BZ 12305 100 First Avenue, Queens. This is the office of Eric Palatnik. I don't see Elise.
Hi, we should also have a Ben.
Benjamin Leonardi.
Mhm.
Okay, Mr. Leonardi, will you join as panelist, please? Raise your hand and join as panelist. Please unmute, sir, and present yourself video and visual if you can.
Should be in the bottom left-hand corner, just in case you don't see it. The
No,
mute
I
button.
see him.
No, him. I'm talking to him. Not
Oh,
you.
I'm sorry. Sorry, Ms. Fullader.
You do this all the time. I know you know what you're doing.
Can you hear me?
Yeah.
Yes, sir, we
Okay.
can. Can you provide visual or is that a problem?
Let's see. Let's see, video, I guess that would be it, right? Allow.
Mhm.
Can you see me now?
Yeah.
Yes,
Perfect.
we can. Nice
Great
to
job.
see you, sir. Okay, please raise your hands. Right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony for this board and to respond honestly to board member questions?
I do.
I do.
Okay, Ms. Fullader.
Thank you. Elise Fullader from Eric Palatnik, PC, on behalf of the applicant. I'm here with Ben, the architect. Thank you, Ben, for joining me today. First is maybe I can show the trash enclosures on his plan because you couldn't see them when you looked.
Yeah, if you could, yeah, that would be
Yeah,
helpful.
so, and then he can speak to the next item. Do you see my mouse? So there's 1, 2,
Mhm.
3. They're all small.
Okay. Oh,
And they're all in the building.
I need to get my eyes checked.
Okay, no problem. There you go. That's the answer.
Oh.
And then Ben can speak to the striping comment.
Okay, I believe you requested that the striping be extended. And with all due respect, is my professional opinion that the striping should not be extended. We have the striping going directly into the office. And allowing any more striping would indicate for someone to go somewhere else. And they should not go in any of the repair areas. The only place that pedestrians should enter is the office, be it handicapped or regular pedestrian people. And that's why I only showed it there.
Okay. My only comment to that is based on your current operation. We have seen vehicles that are parked in front of that parking space that is C12. And that, I mean, I think going forward, that may happen. And so you need to then notify the operator that that's not a parking space. And same thing with the area that is in front of the building on 101st Street. There isn't any sign that is mounted on the wall that says no parking in this area. And so that's why I asked a striping area indicate with saying no parking. So that way it's clear that no parking can happen in front of that building, because that will affect that will result in vehicles encroaching onto the sidewalk.
All right, may I respond to that?
we show a sign on the wall. If you'll notice, there's an arrow, provide no parking sign on the wall. Now, with all due respect, I met with the owner about 2 weeks ago. He wanted to put the sign up immediately, but I said, wait till the hearing to make sure we put the proper location of the sign. There's also a sign on the fence that says no parking. And we also stipulate no parking in front of the garage area. We also met with the tenant in the space and told the tenant explicitly, both the owner and I, that there should be no parking there, because if you park in that area, you'll be encroaching over the sidewalk. So we have it on three of the 4 floor plans showing where the no parking sign is. If you look at the other plans, you'll see one is on the wall and one is again on the floor plan of AP 102 that says no parking sign. So it's not there now, I will admit that, but the owner is waiting for my directing him to do it. In addition to the striping, he wants me to tell him how to stripe the area. Like I said, the parking space, the handicap space, if you would notice, we made it an extra large space. The space itself is 11 feet wide with an 8-foot passageway on the side. So it's ample, and I would not like to deprive someone parking in C12 because it should not impact the handicap spot.
No, I don't think I'm saying that. What I have noticed from the photos that's been submitted by you, by your team, that is that currently there are not only is there a car that is parked on the spot that is C12, but there's also another car that is parked in front of it towards the building.
I agree, and I explicitly told him that's not the way. As a matter of fact, I brought the plan to him, and I said, this is the way that it has to be parking. You cannot have cars stacked on the site. I gave him the plan, and like I said, once we have our hearing and we get an approval, he wants me to direct him how to lay out, the striping and the signage. And that's basically it. But I did not want to increase the striping because striping is an indication of where handicapped people will walk. And I don't want them to walk anywhere else other than directly into the office where you see the arrow.
Okay, all right. Thank you
So
for that.
I think I answered the 2 questions. I don't know if there's anything else.
No, at least my questions have been answered. Any questions or comments from the commissioners for the applicant team? Okay, let's go to the public then.
Chair, the feedback from the neighbors.
Oh, so we sent
Thank
out a notice, but on the notice, it told them the date of it said we'll either be meeting on Monday or Tuesday. This is how to sign in. This is who to contact with any comments. So we told them to contact the BSA if they have any comments. So
Yeah,
we said
so
submit, we followed the notice that you normally do during hearings, but we sent it certified mail to the neighbor.
Okay.
Okay.
And we have not received anything to date.
Not that I'm aware of.
Yeah.
I don't know if Vimray's received anything.
And you'll have another decision hearing, so if anything comes up, you can let us know.
Yep.
All right.
Thank you.
Okay, the case we're currently discussing is 245-32BZ, 12305 101st Avenue, Queens. Should you wish to discuss, dial 646-558-8656, or outside the city limits, our toll-free number, which is 888-475-4499. You will enter the webinar ID number 897-1392-1890 and the pound sign. At the next prompt, you will press the pound sign only. Once you're in, press *9 to raise your hand, *6 to unmute if you are on the phone. And if you're in the Zoom room already, please raise your Zoom hand, which is the little hand at the bottom of your screen. If you wish to speak, once you're permitted in, you will have 3 minutes in which to discuss your issues.
Okay. So what I would suggest, since there are no other questions, comments, I would recommend that we close it, but in the meantime, between the close and the vote, I would like you to give direction to your operators or owner, whoever is going to be responsible, to put up the sign and to stripe the walkway area and the parking spaces.
Sounds good to me, Ben. Sounds good to you?
Thank you. I appreciate that.
How much time?
How much time do they have to do that?
Well,
have to
it's
help.
you have to tell us how much time you need.
How long do you think they need?
Well, I don't know. They're expecting snow tonight, so they obviously can't do anything with bad weather. Could we get 3 weeks? Is that the law?
You can have 1 month.
Okay, 1 month will be fine. And then what we'll do is, I guess, send photographs, right, Elise?
Yep,
Yes.
perfect.
Fantastic. All right, thank you.
Do you want any, is there any corrections to the plans, Madam Chair? No, right?
No.
Okay, so it's photos only. Okay.
Yeah.
Okay.
Okay, so any other questions or comments? If not, I would make a recommendation to close.
Okay. Just let me get the vote sheet, sorry.
And I just want to, Ms. Palade, any other improvements that we have talked about during this time period that I may not have mentioned today, please make, try to take care of it between now and the 1 month submission. And your submission can be, since these are photos, it can even be like a week before the hearing.
As long as the weather, we'll do everything weather permitting.
Right. Just keep the project manager appraised. If you run into issues and that has caused a delay, if we can give you extra time, just let us know.
Okay, thank you so much. Appreciate it.
Thank you.
Okay, the motion to close, Chair Shanda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
Okay. Item number, thank you.
Thank you.
Item number 14, 16755 BZ, 2065 Clintonville Street, Queens. This is Dan Ash, I think. Daniel Ash, yeah. Please let Mr. Ash in. Please join us panels, Mr. Ash. Thank you.
Good
Do you
afternoon,
have anyone
Commissioners.
else with you, Mr. Ash?
No, just myself.
Okay, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to the board member questions?
I do.
Please state your name for the record and proceed.
Danielle Ash.
Okay,
Go ahead,
please.
Mhm. I heard the commissioners' earlier discussion. I wasn't sure if you were finalized on the location of the drains, but I could show you again on my screen if you'd like.
That would be helpful. Thank you.
Sure. Okay. Right, you should be able to see my screen now. So on the drawings, we showed the 3-yard drains here, here, and here. And then from the photographs, you could see this is the first one over there. Then the second one is over here in front of the building. And the third one is here on the first parking space.
Okay.
That matches on the drawings, the same 3 locations.
Okay.
Can you go back to the first one, please?
Sure.
You see how clear is that one, and I can see it.
Mm-hmm.
For the other two, please give us 2 pictures similar to this one. If you go to
So
the
that-
other 2 pictures, you can tell whether they are clogged. The reason for the for the pictures is not just the location. I already knew the location from the location plan you provided, but we just wanted to make sure that it's there and it's clear.
Okay.
Like there is no dirt in it. This is the reason I asked for the 3 photos. And I appreciate you provided them. Thank you.
Yes, that should be no problem. I also heard one of the commissioners mention something that it was stated was actually brought up in an earlier hearing. When I went back to listen to the earlier hearing, I don't recall hearing that. It was regarding sale items near the dispenser. So I've already spoken to the dealer since the call earlier, and he said he will take everything away. They were selling just a windshield wiper fluid at the attendant area next to the pumps, but he agreed that he will move that inside. There was also a question about on the plantings that some people felt they were not sufficient. I know it's winter, so they're not, a lot of things are bare, but I looked through the photos and I thought they did a pretty good job of having plantings throughout, including the back where no one even goes. They have plantings back there. And I know they're pretty small, the shrubs at the moment, compared to the big ones, certainly that were existing before.
Is that 4 foot high? Because the plan says it plant trees that are 4 foot high or something like that.
I think it'll get this. It looks like it's about 3 feet right now.
Yeah, I mean, your notes then somewhere I read it said plant 4 to 6 foot high or something like that.
Yeah, I think that's the expected growth of the shrubbery, but not the current size.
All right, well, that's just one portion of it, but there is also the lot line that is near the Clintonville Street. That also is sparse. And this growth it still looks sparse. Even though they may grow to that full height, it is going to be sparse.
Okay, I will let him know to try to put
You
some
need to have
more.
much dense, yeah, much more dense.
Yeah. There was also a question about this area here, this enclosure. I talked to the dealer. He said that he was keeping inside there things like snow blower that would only get used a few times a year and not have that out in the open.
Okay. Well, then revise the note because the note right now calls it metal trash enclosure.
Mm-hmm. Okay. And Commissioner Sheta had mentioned about the cracking, which I hadn't noticed it before. I talked to my structural engineer in my office. He said it doesn't look like it's any imminent danger, but he would go out to the site and make sure that the site is level so that he can issue a report so we could say that it is safe.
Is there a differential in grades between the adjacent lot and your lot? And if yes,
it did not look like it. I looked through Google Maps of the neighboring property. I believe they just have a very high fence that they put up. They wanted to have a fence higher than our property. I guess to keep their view better, but it looked like it was about the same grade.
Okay.
My structural engineer thought that it could be some cracking and maybe minor repairs we would do if we thought, but he wasn't too concerned about it being. I've seen other walls where they're really out of plumb, and looking at this, he wasn't so concerned. But we will look into it. I'll send him out to the site to verify for sure.
Being diagonal tells something in the language of structural engineers, so that's why I caught my eye.
Mm-hmm. Yeah, good eye. I believe that was all the comments that the commissioners had during the review session. Let me know if I didn't address anything.
Did the drawing, you mentioned the drawing needs to show the 3 drains, or they already on there?
The drawing, sorry.
The drawings do show the drains, yeah.
Oh, okay, good.
Yeah.
I'll mark that off.
So, any questions or comments from the commissioners for Mr. Asher? Oh, sorry, Mr. Ash. Can whoever is sharing the screen, can you please remove? Okay, thank you. Any questions or comments from? Okay, let's go to the public then.
Okay. The case we are currently discussing is 16755 BZ 2065 Clintonville Street, Queens. Should you wish to discuss, dial 646-558-8656 or 888-475-4499, toll-free number. You will when you are entered, you enter the webinar ID number 897-1392-1890 and press the pound sign. Once you, at the next prompt, you will press the pound sign. Once you're in, press *9 to raise your hand, *6 to unmute to speak if you are on the phone. If you're in the Zoom room already and wish to discuss this case on Clintonville Street only, please raise your Zoom hand. Once you are permitted in, you will be given 3 minutes in which to discuss your issues.
Okay. So Mr. Ash, you need to revise the plan to change the a metal trash enclosure to a storage enclosure, metal storage enclosure.
Agreed.
Okay, and add more planting on the plans. And provide photos of the dispenser being cleared of sales item.
Correct.
And
close up of the drains.
And close up of the drains. And when do you think you will be able to do the landscaping and fixing the asphalt?
It's almost March now, but probably not until middle of April when the weather is more consistently warm. So I would say we should be ready for our last hearing in May.
Okay. All right.
I just wanted to bring up one other point that we had discussed a long time ago. I mean, it's been a while since the last hearing, that this site had the 10-year grant that we were looking for was not from the date of the last board approval, but from now. And we discussed that being something you would be allowed to do. And I just wanted to make sure that we remembered that for going forward.
Okay. When was it? When did it expire?
I believe it was 2015, so that this renewal would bring us only to 2025.
Yeah. Right. So it gives you only like literally just about 2 years or less than that.
Yeah.
Okay. Any concern, commissioners? Do you have? Do commissioners have any concerns if you were to grant it 10 years from now? As opposed to, okay, all right.
Thank you, commissioners.
But I think for us to do that, I definitely want to make sure then the landscaping is in place. And if you can even get the and get the asphalt fixed up. Before the hearing, so that we can have a nice, clean, landscaped plan site for the next 10 years.
Agreed.
Yeah. All right. No.
Oh, and Mr. Ash, please don't forget the engineer's letter.
Oh yeah.
Yes.
And letter. Yes. Thank you.
Okay, move on, Madam Chair.
Yeah, I want to make a motion to close.
Oh, I'm sorry. Ooh, sorry about that. Motion to close, Chair Chanda.
Aye.
Vice Chair Shabeta.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Yoon.
Aye.
Okay.
So we will schedule this for May hearing, either the first May or end of May. That will give you
Okay.
plenty of time to take care of all of the.
Good.
All right.
All right.
Thank you.
Thank you, Ray.
New cases, item number 15, 13546 BZ, 3802 Avenue U, Brooklyn. So again,
Hi,
Ms. Kelsey.
Andrew Stewart should be with us.
Mr. Stewart, okay, please join us panelists. Great. Ready? Please unmute. Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
I do.
Please state your name and proceed.
Elise Fullader from Eric Palatnik PC. We heard your comments and I'm going to go through them. The biggest comments of them all is, yes, gas ceased before the last time it was renewed. And as part of the last renewal, they said we could put back gas. So it's been a multiple decades. So you are correct about that. I can look into the year, but I think we had a little bit of trouble figuring out the exact year, but we know it was before the last resolution.
It was even before 2005. If you look at the resolution wording,
Yeah.
it was even before that.
And then I guess my question, and we don't have to go through each of the comments because we need to figure out how we're filing this, but my question is, if we don't change the size of the building, if we maintain the size of the building, do we have the right, and maybe this is a Carlo question, but do we have the right to change it from automotive repair to C-store?
Yes, that's my understanding. I don't know if Mr. Costanza is with us for this meeting. I think he had another meeting to attend to.
Okay, no problem. And I can call him about that.
You can follow up with it, but way I'm reading the text, it seems you should be able to. It's within the same use group.
Yeah, totally. Use group 16.
Right. So you should be allowed to do that. And the convenience store is an accessory use to the gas service. And so, yeah, but you won't be able to expand it.
Okay, because that's something we would want to look into. I spoke with ownership based on your comments. And then you asked about the FEMA map. It is I checked again, it is in the A zone, it is in a flood zone, but I'll look through the record again to make sure we have one consistent map. And then the status of the underground tanks in the notice of comments. We wrote that there are 3 ASTs at the site for waste oil, lube oil, and 2 fuel oil, which will be removed at this application. FDNY and New York State DEC records will be updated to detail the removal of these ASTs as appropriate. Are you looking for something more than that?
Well, AST is above ground, right?
Oh, above ground, but not below ground.
Right.
Oh.
I'm looking at USTs. But with relation, this would be when the gasoline service station ceased to operate at some point, the tanks had to be sealed and closed, and an appropriate report had to be filed to DEC.
That makes sense.
Or a fire department. So you need to look into that and make sure that was done correctly, and any spill reports also.
And for the FEMA, if I may, for the FEMA, you already submitted 2 maps. You don't have if the maps that you submitted are okay, are intact, are correct. We just need a clarification. You don't have to worry about additional maps and submissions. Just a confirmation. I'm sorry, not clarification. A confirmation from whoever prepared the maps that yes, it was AE before, and now it's Zone X. That's what we're looking for.
Okay.
If the maps are correct again.
Okay, no problem. That seems easy.
The confirmation of which map is applicable right now.
And then, so thank you for clarifying the UST versus the AST comment. And then in the statement of facts, we write that the automotive repair operates from 8 a.m. to 5 p.m. It's in the description of the premises.
Okay. So then this will go from 8 a.m. to 5 p.m. 5 days of the week to a 7-day 24/7 operation.
Yeah, at least just for the gas, because usually gas stations are open 24/7. But whatever, we would like the whole thing, but at least for the gas portion.
Mhm.
And I believe there's also a gas station across the street that operates similar.
Okay.
And then you asked about the community board speed bump. At the community board, a woman came who goes with her child to a park that's across the street.
Mhm.
And so a concern was that just to make sure that cars are not driving fast to enter gas stations, even though there's a gas station also across the street, when community members are taking their kids to the park.
So my question is, why do you even need a curb cut there?
So to add to that, we have hired a traffic engineer, which just got hired because there were traffic questions that came up that we didn't have a chance to answer in the notice of comments. So I would like to get back to you on that with the traffic engineers going to answer those questions we were unable to answer in the notice of comments.
Okay, so the fear is from not the current traffic condition, but future traffic condition, speeding to get to the gas station.
Yes, because it's been an automotive repair only for a while.
Mhm. Okay.
And then you had comments about design, and once we figure out how we're filing, we'll rewatch the review session and address
Right.
the design comments.
Right. I just thought I'll let you all know my thoughts, and you can factor that into your design, so we don't have to go through too many iterations, but you have to change the whole application.
Yeah.
Submission, and you have to also discuss the neighborhood character and the impact that would be posed by the change of use from an automotive repair to a gasoline service station, which will function 24/7 at this site. And that means that would have more of a visual, noise, lighting, and traffic impact. So you need to kind of go through how the proposed change would or would not, and should it, how are you addressing those
Okay.
through design measures and operational measures.
Okay, and we're gonna call Carla to look into potentially, like I said, maybe we can not kind of keep it the same-ish by not making it an expansion. Like I'm saying, keep it as an SOC if we don't expand the building.
Yeah, that is a decision you will have to make with your client and follow up with Carla. Yeah.
Yeah.
Any questions or comments from the commissioners? Okay, let's go to the public. Oh, sorry. Yes, Ms. Matias?
No, I guess because they're gonna still do design, so the bollard question, you had mentioned bollards.
Right, those are the detailed design
Yeah,
things
so,
that
okay.
the applicant will look into.
Okay, I just want to make mention, I didn't hear it repeated, and graffiti.
Right.
Oh, yeah, for that. So we'll tell the client to paint that over now.
Okay,
Yes.
I just want to make sure I didn't hear it mentioned, sorry.
Yes, thank you for bringing that to our attention. Thank you, Ms. Matthias. Yes.
Okay. Neighbors, is that what you want to do?
Yeah.
Okay. The case we're currently discussing is 13546 BZ 3802 Avenue U, Brooklyn. Should you wish to discuss, dial 646-558-8656, or outside the city limits, toll-free number is 888-475-4499. You will enter the webinar ID number 897-1392-1890 and press the pound sign. At the next prompt, you will press the pound sign only. Once you're in, you press *9 to raise your hand, *6 to unmute since you are on the phone. If you are in the Zoom room already and wish to discuss this project at Avenue U only, please raise your Zoom hand, which is the little hand at the bottom of your computer screen. Once you are permitted in, you will have 3 minutes to discuss. Ms. Folger, how much time?
Okay, so this is the big question. Is it possible to get something like 5 months? Because if we want to refile it in a different way, we're going to need to get our act together in a different way.
Yowza.
5 months.
Or whatever you think is appropriate. We want a good amount of time because we have to if we have to redesign, that takes a few iterations back and forth between us
That's
and
fine.
the client.
Okay, I understand. All right.
5 months, okay.
And in the meantime, as Ms. Matias reminded you to have your client remove graffiti and keep the site in a presentable condition.
Understood. So. Thank you so much.
Yeah.
Not yet.
And I will not be surprised. I mean, I would think you should also be prepared to have a tech memo with regards to the traffic.
Yeah, so that's also something we have to work on. Like I said, we just got a traffic engineer hired, the one we usually use, and we might have to do some sort of, review of the site. So that also takes time.
Right, but also with the underground, you have to do a spill report and all of that, so.
Yeah.
I want to check with Tracy and stuff.
Yeah. So we'll work on all of that in that time period.
Okay. Public is 2 minutes is up. Okay. We're good.
Yeah,
Nope.
I think we're good. Thank you.
Okay, move on to the next item.
Yes.
Next item is item number 16, 36487 BZ 1719 1720 Flatbush Avenue, Brooklyn.
I just want to note while we're waiting, I think it's 1710-1720 Flatbush, Brooklyn. I had some trouble finding it when I was on my site visit and I realized I had the wrong address.
Oh.
I mean, that's what's on the lineup, but I'm sorry. We'll correct. We'll take a look at that and correct it.
Yeah, let's look into that and correct it. Thank you. Thank you for pointing that out.
Thank you, Commissioner.
Yeah, I think the applicant's drawing has it as 1710 Flatbush. So.
All right. Maybe on the application form, they did it wrong. Okay.
Yeah, so maybe the applicant can.
Alexia? Okay. Are you the only one, Alexia?
No, I'm actually just waiting for the architect, Michael Just, to join. Is he in the waiting room?
Yeah, he's there. Please let him in, Steve. Thank you.
Okay, I think we're ready.
Let's have him unmute, please. Oh, Mr.
did.
Just, unmute.
You did.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes, I do.
Okey doke. Please state your name for the record and proceed, Ms. Lansman.
Michael
Hello.
Just Architecture. Oh, sorry. I jumped the gun there, sorry.
All good. Hi, my name is Alexia Landisman from Sheldon LaBelle PC on behalf of the applicant. Good afternoon, commissioners. We have attended the executive session. We heard all of your comments. The first one was with regards to the compliance chart. We will revise the compliance chart to include all of the grants and to make that a lot more clear. The other comments were in relation to the parking and signage, which is why we have the architect Michael Just with us here. And I'm actually going to relay this conversation to him. But before I do that, I just wanted to make note that I did speak with the client and the clothing bin on the site is no longer on the site. And so we will revise the plans to omit that clothing bin from the site plan.
Good.
Actually, my last site plan doesn't show it. So I don't know which one you're looking at.
I think it is either it's in the document. Well, no, the plot plan A00100 shows existing clothing bin.
A00100. We have a T001. Oh,
This was submitted on 6/27/2022.
all right, I'll look at it.
Well, that's an old drawing, and that's the only drawing. Yeah, that's the only one that we have on file. That is the latest set of drawings.
All right, I'll look at it. We'll remove it. It is gone.
Yeah, good.
I had a question about, you wanted us to split up the signage into two streets. Since this is a triangular lot, it's kind of hard to decide which street to put the signs on. My suggestion is, since most of the signs are perpendicular to Flatbush, to put the wall signs on the building on the East 34th Street side, and the pylon sign on Flatbush Avenue, if you still want them split up. Again, it's a triangular lot, and the signs face the point of the triangle, which is the intersection of East 34th and Flatbush.
I think your business is oriented more towards Flatbush, so that makes sense to do all the signs that are perpendicular to Flatbush, and the signs, you have signs also on Flatbush.
No, they don't exist anymore.
Oh, they don't exist? Okay.
No.
Okay.
So you want everything on Flatbush? If you do, my sign analysis is correct as is. If you just want me to clarify that we're, doing all these calculations just for the Flatbush side, I can add a note to that effect.
Okay, so then just put a note in your sign analysis that even though it's fronting, facing the triangle, the analysis has been done for the Flatbush Avenue frontage.
Okay.
So this way we know that you picked a.
Okay. I also already did a test run on the bollards and chain link that you want. That's not a problem. We already have that on the site plan. On the next submission, you'll have it.
Yeah, it's not only just on the plan, you need to install it.
Right. Okay.
Okay. So just so I'm very clear, it would be along the property line with 5-foot gaps, each one of these metal, not plastic ones.
Exactly.
Right, the solid metal ones.
We're gonna mount them 3 feet into the ground.
Into the ground, and then you will have chain link fence. Where basically our concerns, as you've gathered from the commissioners, is that there are vehicles that are parked on the sidewalk.
No, that's fine. We can make that happen.
Right, and this is going to be on a short leash because I'm not sure the applicant is recognizing that it is.
I've spoken to the applicant after the executive session. They are aware of the bollards and they will be installed.
Right, while that would contain those 6 vehicles from spilling onto the sidewalk, I still remain skeptical that whether the operator will drive the car onto the sidewalk. And in addition to those 6 that are already in the parking space, you will have 2 more spilling on either sides of the sidewalk. And to me, that is a concern. And so that is why I want to put this site on I would like to put this on a short leash, because I don't think the applicant is recognizing the amount of violation this would result in, because it's not in compliance.
Well,
and operator has to provide an operational plan stating how it will ensure that no vehicles will be parked on the sidewalk, and it is not anybody parking vehicles. It is their cars that are waiting for repair are being parked on the sidewalk, or it is the employees who come there and they will park their car. Either one of them, it belongs to the use. It's not someone else who just leaves the car behind. So a very thorough operational plan has to be provided.
Understood.
And the applicant, the operator / owner, whoever is responsible for maintaining the site, has to provide that letter signing it. And I'm going to have that in the resolution.
Understood. And per your earlier comments, we'll also have a sign installed saying that there's no parking on the sidewalk as well.
Right. This is mostly along East 34th Street. It is less along Flatbush because there is more pedestrian traffic. So It is along East 34th Street frontage where the building has a dead wall. That's where, if you look at Google Street Views, you can see that.
Do you want a sign mounted on the building and
Yeah.
on one of the bollards? Or just the
No,
building?
with the bollards, there is of no use. You're talking about the sign on the bollards?
Right. That's which leads me to my second question. Is 4 feet high high enough for the bollards?
4 feet high should be enough for the bollards, yeah.
Okay.
Yeah. Yeah, and you can put a sign saying no parking on sidewalk.
So we'll put one on the building and I'll put one somewhere in the middle of the bollards on East 34th. We'll just mount the sign on a pole. It'll be minimum 7 feet above grade to the bottom of it.
Yep, I hope that works, and then an operational plan.
Okay.
Okay.
We are prepared to move on this quite quickly. We are hoping to close the hearing today and provide this before the decision hearing. Provide all of this information and operational plan and installation of the bollards. I just want to defer to Michael on how long it would take to install the bollards, just to give us an estimate on how long we need.
To install,
lighting
you
plan
can't
also?
install them without a permit. We need an approval for that. And it's part of the BSA case.
No, you don't need approval for bollards. I don't know. Why would you need approvals for bollards?
It's basically fencing.
So if you are going to install a fencing along the property line, you would need an approval from DOB.
Requires a permit, yes.
That is news to me because we just had another project site provide bollards without having to go through DOB.
If you want the owner to do it without a permit, take the risk, that's fine with me, but my understanding is any fence on the property line is filed with DOB, and I've been doing this for many years.
Well, I'm not going to close this case until I see the bollard, so you figure out a way how to get that.
Alexia will just tell them to install. I have it on the plan already, so I'll tell them.
You can go to DOB and find out and provide a letter or that, this would be okay. Something, if you're, I understand and I respect that you don't want to, have your client incur fines for something that would be in violation, but then find out from DOB whether that's really what it is. Because I think if you're doing a structural wall, maybe, but this is not a structural wall.
Any fencing requires a permit.
Okay, to me, that is new. That we have done many projects where fencing has been put up on a moment's notice and nobody had any issues with it.
Because nobody caught it. That's fine. We'll put it up. It's okay. We'll put it up.
Okay. Yeah, this site has been a troubled site for a long time. So I really am loath to let it go without seeing the improvement that we are asking you to provide.
So I understand. It's not possible for us to close, even though we would probably do all of this installation before we get a decision on the calendar.
Yeah, I want to see the improvement before even we close it. This would be an exception because there's been so much problem with this site.
Okay.
Yeah.
I'll say that to the client.
I think I just want to be very clear with all the applicants is that when the site is maintained in compliance and with all the board conditions, the little changes, we can be flexible in granting a closing and making the improvements and then voting on it to help expedite it. It's in situations where time and time again, the applicants or client is in violation of the condition is when these kind of situations arises where we are not going to close until we see that improvement, that step taken to make that to address those concerns. So I think it's in everybody's best interest to be comply to comply and speed up the extension terms by doing so. We are not holding it up. I just want to be very clear.
Understood. I'll relay this to my client and we'll get on that.
Thank you.
Madam Chair, did you mention the lighting plan or did I miss it?
I don't think we need a lighting plan in this case because this is,
Okay, this is my
the
notes.
building is facing the street.
Okay, it was in my notes, so I just want to
Yeah,
make sure.
no. This building does not need any lighting plan.
Okay, so I'll take that out.
I think the lighting plan you were talking about was for the next case this morning, and there was a mistake of maybe it
Yes,
was-
you missed me. Yes.
This is Nas's comment, Commissioner Shedda's comment, so. Okay. Okay.
Okay, so how soon do you think, let's go, any questions or comments for the applicant, commissioners? All right, let's go to the public, please.
The case we are currently discussing is 36487 BZ 17, 19, 1710, 1720 Flatbush Avenue, Brooklyn. Should you wish to discuss, dial 646-558-8656 or the toll-free number, which is 888-475-4499. You're outside the city limits. You will enter the webinar ID number 897-1392-1890. Press the pound sign. At the next prompt, you will press the pound sign only. Once you're permitted in, press *9 to raise your hand, *6 to unmute to speak if you are on the phone. And if you're in the Zoom room already and wish to speak, please raise your Zoom hand, which is a small hand on the bottom of your computer screen. Once you are permitted in, you will have 3 minutes to discuss your issues.
So I'm going to just defer to Michael on this. How long do you think it would take to install or in our case, reach out to the DOB? How long should we ask for until our next hearing so we can install the bollards?
I think it's really a question for the owner because they have to hire someone to do this.
Yeah.
As far as my stuff, as far as changing the site plan and the sign analysis and so on, I'll have it to you in the next 3 days.
Mr. Just, I'm looking at the photos that were submitted, photo number view 7. And in view 7, there is a sign. I don't know whether that is behind the building or that is in front of the building, which says Eagle Auto Repair. Is that the one that is the triangle?
That's the perpendicular wall to Flatbush Avenue.
Right, and then there's one that's mounted on a column.
That's the one, that's the corner of the property where East 34th and Flatbush meet.
Okay. Got it. Okay. And there's none along Flatbush Avenue frontage.
Nothing on that, nothing on
Okay.
East 34th as well.
Right. Okay, yes, I see the pylon. Okay. All right. And are there any vehicular parts and things being stored in the open area?
No.
Okay. All righty.
So I think it's best that I speak with my client first to see what the status is on hiring someone before requesting the timeframe. Would I be able to email Tony once I speak with the client?
You can email me, but Vinroy Bell is also the project manager, so please include him in the email.
You got it.
Okay.
Yes, and Madam Chair, if I could just address, if this could be a quick turnaround, because we typically schedule everything by the end of the week.
Mm-hmm.
Got it. Okay.
Thank you.
Fine today.
Thank you, Carlo.
Thank you.
Okay, move to the next one, Madam Chair.
Yeah.
Item number 17. Oh,
Thank you.
we're good.
Thank you.
Thank you both for appearing.
Yes.
Item number 17, 3109 BZ, 11704 Supton Boulevard, Queens. There's no public. I don't see anybody. Vinmer, you have a number for these people?
Let me try to pull it up.
Wait, I don't see anybody coming in. I don't see anything. John, something. Let's see.
Number I have 718-545-3659. I'll try to type.
What do you want to do? Do you want a second call this?
Do we have any other case after this?
Court Street? I mean, I
Court
don't,
Street, we are going
we're
to
gonna
call
have a
it
second
tomorrow.
call, right? We got some,
Right.
sorry, Jella, is that a final letter? Wait, fire department came up with something. I'm sorry, I don't want to speak on the record.
All right,
All right,
nothing
I
has
guess
been
it's-
submitted officially, so. All right, we have to, let's be on hold and see if this is not acceptable. We need to really send a dismissal warning letter.
Yeah. Okay, so what do we want to do? Just,
Let's let our project manager call the person to get on the call. And we can put that pause or break notice.
want to take a 5-minute break?
Yeah, let's take a 5-minute break.
Okay. Steve, 5-minute break? See if Ben Roy can get him on the phone. Thank you.
Okay,
We're trying to, I'm sorry, Madam Chair, that we're trying to get the applicants to try and get to log in.
okay.
Yeah, so where it says, you see it, register in advance? Yeah, join this panel. Yeah, register in. Yes. All right, even if you don't have a camera, look, you need to get in to the meeting.
Why don't you have camera still participate?
You need to participate, okay, please? Okay. Yikes, sorry.
Let's remove the break. Is the person on?
He's trying to get in. Yeah, he's in. Steve, let him in. He's there. He may not have a camera though, Madam Chair, so just as long as we have someone to speak.
Right,
Swear in.
yes.
Mr. Chrysler? Thank you, sorry. We're back on the record, ladies and gentlemen. This is Board of Standards and Appeals public hearing for February 27, 2023. Mr. Chrysler, can you unmute, please? Mr. Chrysler. There we go. Okay, Mr. Chrysler, can you hear me? Mr. Chrysler? There you go, Belt.
Oh,
Could we call him? Could we call Mr. Chrysler?
yeah. Is there a way to
Vinroy,
do
can
that?
you call him?
I'm on the phone with his secretary is talking to me right now about unmuting.
All right, his hand is up again. Can you, Mr. Chrysler, can you unmute? Are you speaking?
He's not muted.
On mute so that he could be heard.
He's not muted. I don't know why we can't hear him. Are you allowed? His hand is up. He joined his panelist.
His secretary says he's going to do it on his iPhone.
He's calling in on his iPhone?
Yeah.
All right. Is there a much easier, is there another alternative?
If Vinroy have him on the phone, he cannot, the microphone cannot handle two-way code. So if you have him on the same phone he's using to participate, I believe.
No, I think he's talking to the, I think Vinroy's talking to his secretary, which is the office phone.
But I could hang up.
Mr. Chrysler,
He's trying to connect.
are you on the computer and speaking?
Or you don't have them call in instead of being on Zoom. Let them call in. Give them the call in information.
Okay, what is the call-in number?
The call-in number is 646-558-8656. Mr. Chrysler, you call in 646-558-8656. There it is on the screen, 646-558-8656. Once you're allowed in, enter the webinar ID number, 897-1392-1890, press pound. Press pound sign at the next prompt. Press *9 to raise your hand and *6 to unmute, but dial 646-558-8656. We'll see you on the screen. Are they ready?
Okay, I'm going to give another 5 minutes.
Is it okay if we take the following case and then we go back to this case?
We don't have a following case. This is the last case for the day.
Oh, I see.
Well, I
yeah.
have to call, oh. All right, you don't want me to call
Yeah.
that one and just say we're gonna defer it till tomorrow, okay,
Yeah, it's a second call, yeah.
yeah.
I see that.
What is he doing, Vinroy?
And until time now that he would call. I hope from her just to make sure that I was not getting the call.
All right.
Oh, it's a call coming in, it's a call coming in. Okay.
Okay, you know what? Let's go to the next case where we say the
Wait, his
second.
phone, the phone is in, you want to unmute on the phone, please?
What is
Mr.
the, yeah, there we
Chrysler?
go.
Unmuted. Speaking.
Hello, Jesus. Okay, Mr. Chrysler?
Speaking.
Yay, great. Let me swear you in. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions?
I swear.
Okay. Go ahead. You heard the board's comments. Please
Did you
respond.
hear did you have the chance, Mr. Chrysler, did you have the chance to listen to the board's review comments at the review session?
Those comments were raised today.
Okay, so Mr. Chrysler, I think you're new to Board of Standards and Appeals, if I'm not correct, if I'm not mistaken, sorry.
You are correct.
All right, so this is how it happens at the hearing. When you file an application, it doesn't mean automatically we are going to approve it. There is a process, and the process is basically, first it starts with the project manager reviewing the application and sending comments over to you. And you have to do a very thorough response of all those comments. And based on that, and not to mention, notice of public hearing and the notice of initial filing, all of those is the responsibility of you, of the applicant, which is you, to be filed. Correct. Those need to be submitted to us prior to us scheduling a hearing. And I don't know if that was done. Okay.
Well, that's why I was granted the hearing.
No, you were not granted a hearing because of that, because at least I did not see on my file any proof of initial filing and proof of hearing. I did not see it. And the community board did not receive any package to date. So typically what would,
certified receipts.
okay, so our project manager, our case manager will work with you in making sure going forward you submit all the information as we require it. Once the initial you have 10 days, I think is it 10 or 20 days prior to the public hearing, you sent a notice where
That was done.
That was done?
Yeah, there were 4 parties notified by certified mail.
4 parties? Okay.
Madam Chair?
Yeah.
May I, Mr. Chrysler, at the time that this application was filed, was a copy of the entire application sent to those same entities?
Time the application was filed, which was in 2019, no, I did not submit copies of the application to those 4 entities.
Okay, so
It was
that
one
is
application.
that is a requirement of
problem,
every
yeah.
filing, that within 3 or 5 business days after the filing, the application must be served to those entities. In addition, most of the community boards will hold their own public process or hearing, and weigh in the form of a recommendation for the application. So even though that wasn't done, we still held the public hearing for this matter. I'm sorry you weren't able to hear the comments this morning. They're extensive. And we will provide you with the YouTube link so that you can hear them. But it's important that that process be followed in respect to our rules. And I will have the project manager provide you with the information on how to accomplish this.
So what you're telling me is that the respective parties have already weighed in, they already have made their comments.
No, that's not what he's saying.
We haven't, we reached out and they informed us that they weren't aware of this application.
Mr.
Well,
Chrysler,
I have certified receipts.
okay, Mr. Chrysler, this case has been under prosecuted. You received a dismissal warning letter, and now the board decided to have this hearing because of the lack of prosecution on this case. So I recommend you listen to the board's comments that were made on the review session, and as the executive director informed you, that he will have that link sent to you so you can review that. I would strongly consider working with the project manager so that you can properly prosecute this case, or and maybe considering hiring someone who has knowledge of how to prosecute cases on the BSA. But there's a lot to do in this case, and the cases and the extension of term itself has some severe concerns that we've mentioned. So please listen to the review and follow those instructions.
I
So
I hate to do this, but I do think a dismissal warning letter must go out to the property owner notifying that there's a potential lack of prosecution happening. And because I fear there'll be no traction on this otherwise. And if that is there, then should you choose not to respond to it, then the variance lapses and the use will not be conforming, and therefore the use will be in violation and DOB will issue violations.
Okay. Simply like I said, it's simply an extension of term.
It's not that simple. It's not you file the application and we just stamp it. The extension of term is granted only when a site is fully compliant with all board's grants. And this site is woefully it is absolutely out of compliance on all measures of prior BSA grant conditions. And you need to listen to the YouTube video link that our project manager will send to you, and you will hear our comments. We are very disturbed by the extent of non-compliance that has been retained of the site, not just now, but it has been an issue with this site even before you joined this, you signed up for this project.
Before I came on board, it was woefully out
Yes.
of compliance.
Yes, it has been out of compliance before, and it continues to be out of compliance. So if it is not correct at this time around, there won't be any extension of term, because we cannot keep having this going on. This is not just a rubber stamping agency. We stand by what we put the conditions on for.
I respect that, miss. So I will look forward to the link and hopefully get the property owner to bring the property up to full compliance.
Right. So please listen to the video, go through the drawings that were, go through the BSA resolutions, look through every conditions that were placed on this site, and abide by all of those conditions and rectify those mistakes on the site. I don't want to give too much time on the to you, because I do not want this use to continue to operate in this manner on the site.
Madam Chair, Mr. Costanza has a sound,
Yes, yes, Mr. Costanza.
Yeah, no, and for Mr. Chrysler also, you know, just to put into perspective, this application was filed in August of 2021. So we're in excess of about a year and a half into this already. So I just want to be clear that, you know, we give a lot of consideration to many applications, but at the same time have to remain fair to the other ones that do get dismissed. So I think the board and the staff has been very generous here.
You have.
So
I will look forward to the comments on YouTube. And
meanwhile,
yeah,
okay.
And I'm also happy, Mr. Chrysler, to be on the call with you with the project manager if there's of any assistance or any clarity that I can provide or that we can provide you. But let's do that sooner than later. So we'll try to schedule something this week or next week. I hope that's fair.
Okay. Okay, and your name, sir?
My name is Carlo Costanza. I'm the executive director.
Okay, that's right. Carlos Costanza, and the project manager is Mr. Vinroy Bell.
That is correct.
And we have directed
Okay,
the project manager to share with you some of the samples that we typically ask the app, and that will give you an idea of the way you need to respond to our comments and all the various steps you need to take to respond to our comments.
Thank you very much.
Okay.
Have a lovely day, folks.
All right, Deputy Counsel, please do send a dismissal warning because I have as I said, I fear it's not going to move otherwise.
Yeah.
And
Yes.
just a note for the staff, we will reschedule this as an initial hearing again, even though we've had a discussion. Instruction to the staff is to reissue a notice of hearing. And Mr. Chrysler, this week, you will provide the entities with the application in its entirety. We will assist you on how to do that, so that we can get this on the right track.
Got it. Thank you, Mr. Costanza.
You're welcome.
Have a nice day. Bye.
Okay.
Okay.
Okay. So I guess we're not going to the public on this one.
Nope, unfortunately not.
Okay. Okay.
Before we close, before we move on, Mr. Costanza, please do let Mr. Chrysler know that he needs to serve another notice, right? You did say that?
Yes.
Yeah, because we're going to issue a new notice hearing.
Yes, Vinroy and I will have a call with Mr. Chrysler this week.
Okay.
We'll go over the process of providing those entities with the application as well as the instruction that when he receives the hearing notice, how that process works. And we will also provide him with the link for the YouTube so he can hear the comments, and I'm happy to sit in with him to go over some of those comments. I am familiar with the site and the application and the concerns that were raised. And we'll take it from there.
Okay, all right, thank you. Sorry about that. Continue, Ms. Matias.
Okay, the next item is item number 18, 2022 2A, 728 Court Street, Brooklyn. So we are going to second call tomorrow.
Yeah, we're going to second call this. It
Oh,
seems.
Jill has a hand.
Sorry, yes, Ms. Prenga.
I'm sorry, I didn't see you. Jella.
Hi. I just wanted to update the board. The applicant is not attending because of the second call, but we did receive a draft sign off from FDNY. It is under review by the applicant because there was an edit made. There was an additional condition added into it. So it's under review by the applicant, and they said they will get back to FDNY and BSA ASAP. If they agree to this letter, all the conditions, then John will issue a signed letter. That's all I wanted to update the board, and we'll send it to the board, distribute it to the board right away.
Wonderful. Yes. Thank you, Ms. Prenga, for staying on top of it and keeping us abreast of changes. Appreciate it. Okay.
Okay, so nothing else. This concludes the public hearing for February 27th, 2023. Thank you, one and all.
Have a wonderful day, everyone.
Yes, we're resumed
You all
tomorrow.